Thank you very much for joining us for this workshop on rights for everyone, positive obligations and the protection of human rights. When Kevin, Anne and I started discussing the idea for this workshop some time ago, we were in somewhat different times. We didn't at that stage know when there would be a general election. We certainly didn't anticipate that it would be in July of this year. And we were discussing it at a time when issues about human rights reform seemed to be part of the agenda of at least some parts of the Conservative government. And there were regular discussions about reforming human rights or repealing and replacing the Human Rights Act. Times have moved on, of course. The wonderfully named Bill of Rights bill no longer is with us, and it does look like the Human Rights Act will live to fight another day. But nevertheless, there are a few things about those debates and those criticisms of human rights that strike me that are relevant for the topic of positive obligations and the European Convention on Human Rights in particular. First, whenever politicians and some people in the media have been criticizing the human rights framework that we have become accustomed to since 1998-2000. There is a refrain that the European Convention is somehow outdated. It's an international treaty from 1950, drafted in the very late 1940s. And this is, of course, true, that it was drafted and adopted in 1949, 1950. But as anyone who's familiar with human rights and the European Convention knows, the Convention has been significantly updated, not just through formal amendments, through the adoption protocols, but much more significantly through the case law of the European Court of Human Rights. And even when the Convention was being drafted, it was recognized by some of the drafters, at least, that the court would play a major role in keeping the Convention relevant. And the court, the European Court of Human Rights in Strasbourg, has done this through a number of different interpretive techniques, most notably saying that we have to interpret human rights to be effective. We have to interpret human rights in an evolving sense so that the Convention is fit to protect the rights of people in a real way in today's world. So the Convention isn't just what was written and agreed upon in 1950, but very much the doctrines and the case law as have been developed by the court since then. And a major part, and this is the second point, a major part of the jurisprudential development by the Court of Human Rights has been the creation of the doctrine of positive obligations. The idea that sometimes, as we'll hear over the course of the day, states have a duty to take positive steps to put in place legal frameworks to protect human rights, or to take operational steps to protect people's human rights, or to protect the rights of people from violations by third parties. And we'll hear a lot about that today. Another part of the criticisms of the human rights framework that we've heard a lot in the last, 14 years, but indeed longer than 14 years, is that the refrain that somehow human rights have been abused, that human rights are a criminals charter, that human rights are a terrorist charter, that human rights are the playthings of lefty lawyers who cunningly persuade judges to adopt radical interpretations of the law. What's really fascinating about the doctrine of positive obligations, though, is that they really do demonstrate that human rights are for everyone. That human rights protect everyone, whether they are disliked, unpopular, whether they're children, whether they are people who've been abused, whether they are the victims of crime, whether they're the victims of human trafficking. Positive obligations really offers something for everyone. And a glance at the recent case law on positive obligations demonstrates this. We have cases from the Court of Human Rights, for instance, at a very micro level, looking at the failure of a state to protect a school child from verbal abuse by a teacher that seriously distressed and psychologically harmed them. And this is something that brings into play the positive obligations of the state to protect school children. At the other extreme, we have positive obligations playing a major role in the significant litigation on climate change, an existential threat literally to the rights of everyone on the planet. So human rights are for everyone. Human rights are universal, if you like, universal, indivisible, interdependent, and interconnected in the mantra of the United Nations. And positive obligations are a key part of ensuring that human rights are meaningful for everyone. And my third, our final preliminary point is I've mentioned various threats to the human rights framework that we have been, those of us interested in human rights, exercised about for many years. To coin a phrase, I'm old enough to remember when it was Labour Party politicians who were saying these comments about human rights protection, and when it was Labour Party Home Secretaries or former Home Secretaries who was warning that human rights protection had gone too far. So whatever happens on July 4th or on July 5th in the United Kingdom, I think it is important that we continue to have these conversations about what is the role of human rights and how do we best protect human rights for everyone throughout the jurisdictions in these islands. So with those preliminary comments out of the way, I'd like to welcome Dr. Vladislava Stoyanova and Dr. Gillian Kane for the first session of this morning.
Thanks very much, Rory, and welcome everyone. It's great to see everyone here. My name is Gillian Kane. I am a lecturer here at the School of Law, and I'm really delighted to introduce Dr. Vladislava Stoyanova, who, as you will see when you hear her, is one of the leading experts on positive obligations. So it's a real privilege to hear from her today. Her work, for anybody who follows the Strasbourg Observers, you'll know that she keeps us all up to date with the latest European Court of Human Rights case law, among many other things. So Dr. Vladislava Stoyanova, she is an Associate Professor of Public International Law at the Faculty of Law at Lund University. She is the holder of the Wallenberg Academy Fellowship, awarded by Knut and Alice Wallenberg Foundation and the Royal Academy of Swedish Sciences. And she's been leading the project, The Borders Within, the multifaceted legal landscape of migrant integration in Europe. She's also the holder of the 2023 Henrik Enderlein Prize for Research Excellence in Social Sciences. And a few of her many publications include her monograph on positive obligations under the European Convention on Human Rights, which is available open access on Oxford University Press, and Human Trafficking and Slavery Reconsidered, Conceptual Limits and States' Positive Obligations in European Law, published by Cambridge University Press. So with that impressive backdrop, it's my pleasure to welcome Dr. Vladislava Stoyanova to deliver our keynote today. Over to you, Vladislava.
Thank you for having me and for the wonderful introduction. To start off, just to link a little bit with what Rory was saying. So when I started my research on positive obligations, actually my main driver for that was that critique that from the state perspective, you never know what is the scope of those positive obligations when they're triggered. So if I were to take the state perspective, I would be extremely concerned because indeed these positive obligations can be quite uncertain and quite ambiguous. So in a sense, we can understand the concern of states. But what I try to do I already have it. With this book is to, on the one hand, to say, okay, indeed, these positive obligations are quite ambiguous, but this is something that is not necessarily negative because human rights law has to be dynamic. It has to respond to the contemporary challenges that we have. But on the other hand, also, if we actually look at the case law of the European Court of Human Rights, the European Court that has been developing these positive obligations for decades, and I would say quite cautiously, the court has developed certain standards that we can look at and try to understand. And that has been my job. So in very simple terms, my objective has been to understand and explain the standard that the court applies when it adjudicates positive obligations under the convention. So in this sense, it's a way to reconstruct the case law that is extremely rich, so that the relevant standards that the court has developed can become more understandable. So in this sense, my work can be described as analytical, but also as descriptive and analytical, to make it easier to navigate for all actors, including states. So in very simple terms, positive obligations will imply that the state will be under the obligation to take some proactive measures to prevent harm or to prevent risk of harm or to address harm, because there is also a positive obligation to investigate the harm. And when an applicant goes to the Strasbourg court and invokes positive obligation, the applicant basically makes an argument that the state, the respondent state, should be found internationally responsible under the European Convention of Human Rights for omissions. So what is key here is that it is an omission that is at the core of the argument. And omissions, arguing responsibility for omissions in itself is quite challenging because it raises certain analytical challenges to which I'll come back. If we look at the case law on positive obligations, and the court has been developing them since late 1970s, and I say quite gradually, this is a cautious court, at least that's how I view the court. And if we look at the case law is extremely rich. So various issues from various spheres of our lives have been adjudicated as possibly involving positive obligations. Let me just give you some examples to illustrate the richness of the case law. For example, when social service departments decide to refrain from taking children into care, children that might be exposed to unhealthy or even abusive family environment. When state institutions somehow fail to ensure public safety at public places, fail to ensure safety on the roads. There have been such cases about traffic accidents. Domestic violence, there's a whole group of cases that are about domestic violence, a whole group of cases that can be clustered as cases about medical negligence, where applicants go to Strasbourg to complain that the state somehow failed to regulate hospitals. Enforcement of building regulations. Where there's also a group of cases that can be generally framed as natural disasters, where people have been harmed because of natural disasters or because of industrial activities or because of the pollution of the environment. And the argument there is the state omitted to regulate the private actor. And recently, of course, we had the climate change cases. So the immediate cause of harm is not an act of a state agent, but an argument is formulated that the state should have acted at the relevant point in time in the past. And if the state had acted, the harm could have been prevented or the risk of harm could have been mitigated or reduced. That's how the argument goes. And in terms of analytical issues, what we need to clear our minds about when an argument is about omission and breach of positive obligations, we need to understand the trigger of the obligation, under what circumstances actually the state had any obligations, what is the content of the obligation, and what is the scope of the obligation. In my understanding of the case law, if we look at Article 2 and Article 3 cases, Article 2 is about the right to life, Article 3 is about the right not to be subjected to torture, inhumane or degrading treatment. So if we look at the case law on positive obligations under these two articles that are considered as enshrining fundamental values in our societies, there is this starting assumption by the court that the state is all the time under this very general and abstract positive obligation to prevent harm. And here I have a quotation from Kurt and Austria, which is simply an example to illustrate how the court formulates this very abstract positive obligation. The first sentence of Article 2 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the lives of those within its jurisdiction. So there is this very abstract obligation to take appropriate steps. But this is quite general and quite abstract. I'll come back to that question of level of abstractness in how things are framed. When it comes to Article 8, which is private and family life, the starting point in the reasoning is slightly different depending on the level of harm invoked by the applicant, because private and family life is extremely wide. The court has been interpreting this in a extremely wide fashion. Anything and anything can be about our private life. So here, the starting point is a little bit different because the court might ask initially this question: was there an obligation to start with? Should the state be under any obligations to do anything in this context? So it's slightly different starting point. But if we go to Article 2 and Article 3, which are about more severe forms of harm, this abstract positive obligation does not tell us anything about what should have been done in the past at the relevant point in time. So the obligation needs to be somehow specified. And that question of specification of the obligations, it has been played a key role in my work and continues to play a key role. So specification will mean that some more concrete measures need to be identified as to what the state should have done. So the content of the obligation will be some more concrete measures, and it's normally the applicant that comes forward with the more concrete measures. The scope of the obligation will mean how many of these measures or how far-reaching the measures should have been. Now, and here when it comes to that question of specification of the obligation, which is a very important question, the starting point that's constantly repeated by the European Court of Human Rights is that it's not the job of the court to tell states how specifically to fulfill their positive obligations. In this sense, there is discretion, margin of appreciation, which characterizes positive obligations because states have multiple compliance options. That's the starting point. But yet, in the reasoning, to actually reason about omission, there needs to be some examples of measures that need to be specified so that an argument can be formulated that the state should be responsible for omissions. So there needs to be certain level of specification, and the court does this in its actual reasoning, despite the constant repetition by the court that states have discretion and margin of appreciation. Now, in terms of assessment of the content of the obligation, the scope of the obligation, and the breach of the obligation, as I mentioned, my job has been to identify the standards. So there are certain standards that are quite consistently invoked by the court and repeated in the case law. And these are the three standards: knowledge, causation, and reasonableness. And my job is simply to explain each one of these standards as developed in the case law of the court. So let's start with state knowledge. For a positive obligation to arise in the specific context, it needs to be demonstrated that the state knew or ought to have known about harm or the risk of harm. So as you see here, the court refers to knew, which is actual knowledge, or ought to have known, which is putative knowledge. The state, and the mere formulation of ought to have known suggests some kind of normativity already here. The state should have known, but should in accordance to which standard? So there's some kind of normativity working in the background. So let me focus a little bit more on this ought to have known standard. There are different ways of approaching the standard, and these different ways have been applied in different cases. So the first possible way will be to ask the question whether the harm was objectively or scientifically foreseeable at the relevant point in time, so that the authorities should have known about it. And this will imply that there were actually relevant scientific studies at the relevant point in time. Now, a problem that arises is that scientific evidence is very often inconclusive. And another key point here when it comes to adjudication of positive obligations, something that the court has consistently repeated, is that the assessment of breach should be made. Assessment of breach is made without the benefit of the hindsight, which means that the court, when it adjudicates the case, has to, in a way, simulate ignorance. The court has to place itself at the position of the state authorities in the past and to ask the question what they knew or what they should have known at that time. And that's key for the principle that no benefit of the hindsight is very important. Now, Another way in which the court has applied in other cases when it considers this ought to have known standard is to ask the question, would the state authorities have correctly assessed the risk of harm based on the information that they could have had if the state authorities actually actively pursued information, which basically implies some pre-existing procedural obligation to do risk assessment. And in some areas of the case law, particularly I had in my previous slide, Kurt versus Austria, the domestic violence case, I think this is already quite fairly well established. In the area of domestic violence, there seems to be some pre-existing procedural obligation that the state has to do risk assessment so that the state knows better. Another way of approaching this standard of ought to have known is to ask, should the state authorities have known of the risk based on the information that was actually before them at the relevant point of time? And from the perspective of the state, perhaps this is the easiest standard, because no consideration will be taken as to whether there was objective scientific studies or whether the state should have actually made efforts to know better. And the fact of the matter is that different approaches are applied in different cases. And this standard of ought to have known is another reason why it might be confusing is that if we look at how the court reasons in actual cases, at the end of the day, it's quite uncertain which of these two standards is found fulfilled in the particular case. Let me be a little bit more specific. So here I have a quotation from Onur Yildiz versus Turkey, which I still consider as one of the leading cases. It was about, in the area of positive obligations, it was about gas explosion at the garbage collection point close to Istanbul. As a result of this gas explosion, people lost their life, property was destroyed. And the argument was that the state authorities should have actually prevented the event because there was knowledge that gas was accumulated at that place and at a certain point it will explode. So what did the court say in relationship to that standard of knowledge? The Grand Chamber accordingly agrees with the Chamber that it was impossible for the administrative and municipal departments responsible for supervising and managing the tip not to have known of the risk. So it was impossible not to have known, so they actually knew, okay? But then if we continue to read down the reasoning, the court says, it follows that the Turkish authorities at several levels knew or ought to have known. And then you remain to wonder, okay, but which of these two standards is fulfilled? Did the court conclude that they knew? Did the court conclude that they should have known? And there's this uncertainty as to which standard is actually found fulfilled, which in a way I'm in full sympathy with the court because the state, sympathy in the sense that I understand why the court reasons the way that it reasons, because the state is an abstract organizational entity and the state cannot really know about anything. And this element of knowledge has to be all the time in a way inferred, and it necessarily implies all the time certain normative judgments about what kind of risks in our society at this particular point in time we perceived as being more important than others. So there is this kind of normativity working on the background. Now let me move to the standard of causation. Causation is important here because there needs to be some causal link between the omission of the state on the one hand and the harm sustained by the applicant. Any engagement with causation has to first of all start with the awareness that ascribing causality in human society is quite complicated. And a further problem is that causality by omission implies counterfactual and speculative analysis. And it's possible to put forward a whole range of possible omissions that might have some kind of a causal link to harm. If we look at the case law, the court has never articulated a causation standard to be consistently applied when it comes to positive obligations. What is clear is, at least one thing is clear, and that's the rejection of the but-for test. The but-for test, which means that but for the state's failure, the harm will not have happened, has been explicitly rejected by the court. This happened a long time ago in the case against the UK. In other cases, the court has referred to this real prospect test, and this is O'Keefe. Is it O'Keefe versus Ireland? I'm not sure about the pronunciation. Again, this is one of the leading cases in the area of positive obligations regarding abuse of children at school. And here the court said a failure to take reasonably available measures which could have had a real prospect of altering the outcome or mitigating the harm is sufficient to engage the responsibility of the state. So here the court refers to this real prospect test, but it's not consistently used in the case law. If we look at other cases, we see that the court uses other formulations, such as, was the harm imputable to any specific shortcomings for which the applicant criticized the state? Not only there is no specific and certain causation standard, but actually, if we look at the case of the court uses different words, different concepts to express that idea of causation, such as attribution, imputability. So different concepts are used. And now in my book, what I say is that this real prospect test that was formulated in O'Keefe versus Ireland seems to be a reasonable way to approach the standard of causation. And more recently, in the Crima Signorina case, actually the court did refer to that standard. Now it's a different question how the court applied the standard to the specific facts. It didn't, but at least we have another confirmation of that causation standard in the Grand Chamber judgment. Now, so establishing causality is it's difficult because there might be also empirical uncertainties. And since the court might not want to see itself complicated with these difficult scientific questions, it has developed in its case law certain techniques to avoid the question of causation. And I have identified at least two such techniques. One is domestic legality and the other one is procedural guarantees. So let me briefly explain those two. So domestic legality will mean that if there are certain standards at domestic level, and here I use the legality in an extremely wide fashion, I mean any kind of regulatory framework at domestic level, and also there might be standards developed at international level. So if there are such kind of standards and the state has failed to meet those standards, the assumption is that there is a causation between that failure and the harm. Whether actually there is such a causation is not really that much relevant. But when we have such kind of standards at domestic level, there seems to be an assumption that these standards form kind of a baseline, and any deviation from that baseline is suspect for the court. So this is one way for the court to avoid the difficult question of causation, and this has been applied in some cases. Another technique will be what I frame as procedural guarantees. So here the court will not look into the question whether there was any causation, but will simply look at the question whether the national authorities had relevant procedures to make an assessment as to what measures should be taken to prevent the particular risk of harm. And if there were relevant domestic proceedings and procedures that have sufficient quality, then the court will refrain from making any substantive causal link itself. And now very briefly on the standard of reasonableness, which I mentioned is another standard invoked by the court. It has been a standard assertion that positive obligations need to be interpreted in such a way as not to impose excessive burden on the authorities. The court has also referred to impossible and disproportionate burden standard. in some cases, to reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge. In the context of Article 8, that's a qualified right. The court normally doesn't refer to reasonableness, but it refers to the fair balance test. And now the question that arises is, what is the standard of reasonableness? And it might be difficult to understand because, again, if we follow the reasoning of the court, often what we see is at the end of the judgment, the court will say, and therefore this was not unreasonable. But exactly understanding what factors, which elements in the reasoning were used to make that conclusion, or which element was given more weight in comparison to others, might be difficult. So what the court has in mind when it refers to reasonableness is general public interest, including public policy considerations, budgetary concerns, cost effectiveness, management of limited resources, also multiple other interests that might be involved, including competing interests and competing obligations. And let me, not sure how much time I have left. Okay, just on this point, because I think that also this is a very important point when it comes to positive obligations. Positive obligations all the time compete with other positive obligations. In some situations, positive obligations compete with negative obligations. And this needs to be explicitly acknowledged. Just to give you an example how positive obligations can compete with negative obligations. There was a case called Hiller versus Austria. This was a case about a person who had a psychological deviation. I'm not sure about the exact diagnosis, but anyway, he was hospitalized. And Austrian authorities decided that the regime that he will be subjected to will be liberal. So he will be allowed to take a walk in the garden. So a liberal regime. During one of these walks, he managed to escape and to commit suicide. The mother went all the way to Strasbourg to complain that Austria breached its positive obligations under Article 2 because it did not impose a more restrictive regime. So obviously, if he was deprived of liberty, he wouldn't have escaped and killed himself. And then Austria said, but look, we also have negative obligations under Article 5 of the European Convention of Human Rights, which is about the right to liberty. And in fact, Article 5 imposes quite strict conditions as to when a human being can be deprived of liberty. So here we had a very clear example how positive obligations might compete with negative obligations. And the court was very clear, and I think this was very well done, saying, well, positive obligations cannot be unreasonable. And in this case, it will not simply be unreasonable, but it might be in breach of negative obligation to demand from the state to go as far as the applicant was arguing. So this is simply an illustration how within that reasonableness standards, there might be competing positive obligations, competing negative obligations, and in some cases, this competition can be quite clear, but in other cases, it's not that much. What I also want to say at the end is that the court, when it reasons, is clearly aware of these difficulties and these competitions, of the competing interests, and I think that the court, at the end of the day, tries to navigate between those competing interests. And so far, I don't think that the court, in terms of how it has developed positive obligations, indeed there is a huge scope of ambiguity surrounding them, but I don't think that the court has developed them to such a limit that we can say that the court has overreached in any way. Because when I started this project, that was one of my objectives. Can we say that the court has gone too far? And then my conclusion was, no, this is a cautious court. I don't think that there is overreach at this stage. Yeah. Thank you for your attention.
Thanks Thanks very much, Vladislava. Would you like to join me here, and we will open the floor for some questions. I think we have about 10 or 15 minutes. Rory's going to help me by coming to you with the mic. So we'll take a first round of questions and see how we get on. So are there any questions from the floor? I see one at the back there, yeah.
Dr. Stoyanova, thank you very much for an interesting, very, very interesting presentation. Would you mind going back to the but-for test and maybe elaborating a little bit more on the logic that the court would apply in such a case? And would you mind, I'm sorry, that's a classic double question in one, apologies for that. Would you mind if you can elaborate a little bit on, I guess, specifically cases around the environment where both negative and positive obligations are questionable? Questionable in the sense that the link between human rights and the environment, for example, is still developing. Would the court be more concerned with establishing negative obligations, don't do harm, or would the court be more confident in exploring positive obligations on states, take these measures, for example, to prevent harm? Thank you very much.
Thanks very much. We'll maybe take one more if there is another one. Rory, yeah, go ahead.
Maybe just echoing some of that, could you elaborate a bit on the difference between negative and positive obligations? And in particular, is there, I mean, the court, it seems, sometimes says, in essence, they're both about finding a fair balance between the public interest and individual rights. So is there a significant difference between how the court approaches proportionality inquiries in negative rights cases and how it approaches positive obligations type cases?
Brilliant, thanks very much. I will hand over to Vladislava, and then we might do another round if we have time.
Okay. So the but-for test. So I think that this test comes actually from English tort law of negligence. And the argument, if such a test were to be applied, the argument will be, but for the omission, the harm will not have materialized. This is a very high standard. And the court rightly rejected that standard. It will impose unreasonable burden on the applicant to make it. It wouldn't be possible for the applicant to demonstrate that if the state had taken this particular measure, it is certain that the harm will not have materialized. This will be very difficult for the applicant to demonstrate, and for this reason, the court rejected the but-for test. And it did well. Okay, the link between human rights and the environment. So the European Convention of Human Rights does not protect the environment. So wherever it's, when a case is formulated before the court, it needs to be demonstrated how the particular applicant suffered harm. So in this sense, causation matters at that definitional level. But in these cases are formulated as positive obligation cases because the source of harm is not a state actor. The source of harm is quite diffuse, actually, if we are talking about climate change. Or if we are talking about pollution by a factory, normally this will be a private actor. So the direct source of harm is not the state, and that's why it is positive obligations that are relevant in these cases. Does this answer the question? Yeah. Okay. Now, the difference in how the court approaches proportionality, depending on whether the case is framed as positive obligation or as a negative obligation. Because first, a relevant clarification here is that if the case is under Article 2 and 3, I think the court always makes it clear whether this is a positive or a negative obligation. If it's under Article 8, then we have this uncertainty. The court said, well, it doesn't really matter. Okay. So if I may limit your question only to Article 8, which is more difficult, and it's more difficult because it can cover a wide kind of circumstances because of the wide way in which the court has interpreted private and family life. Okay, so if it's a negative, I think it does make a huge difference, just to directly answer the question. So if it's a negative obligation case, the first question that will be asked, is this in accordance with the law? So that's the legality test. So the measure of the restrictive measure or the measure of intervention that the state has taken that's arguably in breach of negative obligation has to be in accordance with the law. And there are also certain standards as to the quality of that law. If it's a positive obligation case, this question will not be asked to begin with. So there is this initial difference. Now, whether there is any difference in terms of the fair balance test, perhaps there is, because if it's a positive obligation, the starting point is wider discretion, because states have more ways to comply with positive obligations. While if it's a negative obligation test, there is also this proportionality is applied in a way that theoretically at least has to require from the state to take the least restrictive measure. Practically, the court is not consistent as to whether it applies the less restrictive means test, but theoretically, if the state takes a measure of intervention, arguably in breach of negative obligation, theoretically, the standard should be that the state takes the least restrictive measure to breach our rights, which means that it has to choose a measure that is the most protective for my interests, like freedom of speech or assembly. And that's a very high standard. So in this sense, the compliance options for the state are limited in comparison with the positive obligation case. But again, the problem here is that in some cases, the court, which is a negative obligation, the court invokes the least restrictive means test, in other cases it doesn't. So there is still uncertainty. But from a theoretical perspective, I will maintain that there is a huge difference between whether the case will be formulated as positive or negative. That was a long answer.
No, very, very helpful. Thank you very much. We have time for a couple more questions if there are any. I have a couple of questions myself, but Conor, you have one. Is there another question or? Okay, we'll take Conor's question and then I'll ask a couple.
Okay, well, thank you very much for your talk. It was really interesting and learned a lot from it. I was just wondering if you could tell us anything about whether, well, it's about compliance basically. Is there a difference in terms of the success rate of cases for breaches of positive obligations? Basically, I'm wondering, do states fight harder, basically, in finding breaches against them where it's a positive obligation? And then the second, if I may do the same as Ivanka and squeeze in a second question. The second was whether you thought the court has overreached in the Kima Senioran case, because it's obviously a pretty controversial positive obligation it's found.
Thanks very much. Is there any final question from the floor? Kevin, you've got one.
Thanks, and excuse me, thanks very much for a wonderful presentation. My question really is around that idea of overreach and whether there has been overreach or the extent to which positive obligations have entered into territory that was, that has been criticised by some governments, or maybe the critique has been this isn't what was originally envisaged in the convention. I'm thinking particularly of some of the social and economic rights that aren't listed in the convention, but there have been cases whereby positive obligations have had impacts through various judgments from the court. I'm thinking particularly around the right to health, and we know that there's quite a wide margin of appreciation that's afforded to states, and there's a limit on public expenditure. But we have seen some cases where approach to healthcare or lack of healthcare has been critiqued through various judgments. I just wonder whether you could speak a bit about that, about the trajectory that positive obligations have been on in terms of reaching over into other social and economic rights in particular, and what the direction of travel is in that regard. Is it Is it getting broader? Is there more teeth to that now? Is the direction of travel increasing in terms of protecting some of those social and economic rights, or are there clear limitations around that, and how you see that evolving over the next period? Thank you.
Thanks, Kevin. One final question from the floor, or okay, Ivanka, we'll let you have we'll have a third one. No, it's all good.
Sorry, I've had a lot of coffee this morning. Dr. Stoyanova, very quickly, is there, in terms of remedies that the court might pursue, is there any difference in the way they're formulated if the obligation is negative or positive? What would a remedy for a positive obligation be? Sorry if that's a very basic question.
Thanks very much. I think we'll leave it there, just so you have some time to answer them. I see we're quickly running towards the first panel, so feel free to answer as many as you can, and then we'll wrap it up. But thank you very much for your generosity with the questions.
Thank you. So the first question, you mentioned compliance. I just wonder what you mean, but are you talking about execution of judgments? Because then it will link to the last question, which was about remedies.
So I wasn't thinking about execution of judgments, but if you prefer to answer it in that way, that's fine. Okay. I was thinking about findings of breaches by the court. So where, maybe you don't know, maybe nobody's studied this, but I was interested to know whether it's more likely for the court to find a breach of a positive obligation. Well, in real terms, actually, I'm wondering if it's less likely, because I imagine states fight them more vigorously than a negative obligation breach, but maybe there's no research on that yet.
So I cannot answer the question because it's kind of an empirical question, and I haven't done this kind of research, whether it's more likely or it's not more likely. But in terms of execution and compliance, again, so that will require a very careful study in the HUDOC execute database to actually understand, once the court finds a breach of positive obligation, what happens after that? What kind of choices are made by the state to actually comply and execute the judgment? And this will imply answer to the question how the state takes advantage of that discretion that the court gives to the states. But this will have to be a research actually about the choices made by states. And this is something that I have not done myself. But it is something that somebody else can do. As to the other question about overreach in the case against Switzerland, no, I think that this was an extremely reasonable judgment, actually, in terms of how the Grand Chamber limited the victim requirement, and then it did find a breach at the end of the day. But again, something that I've been mentioning, compliance options, the states have discretion how to comply with the judgment. So in this sense, it was a cautious judgment, let's put it that way. So what now we have to look at is actually the compliance, how Switzerland, what choices it has made in light of that judgment. And the last thing that I heard is that the parliament actually rejected the judgment. But yes, as to socioeconomic rights, I don't think that the court is very keen to develop the socioeconomic rights under the ECHR, and my sense would be that the trend is not in the direction of expansion. Of course, one possibility is non-discrimination with the right to property, or non-discrimination with private and family life. But again, this will be a non-discrimination argument. But in terms of substantive standards, I don't think that the evolution is in a direction of expansion. Yeah.
Thank you so much.
This relates to subsidiarity argument, yeah.
Yeah, thank you so much, Dr. Stoyanova. Really, really insightful. And I think I'm sure many of us in the room, we're often thinking about the sort of practical implementation or maybe on one particular article. And I think it's really helpful to take a step back and think about, these broader conceptual and analytical parts. So I know I found it really helpful. I'm sure that everyone else did. So really, thank you very much for your time. And if you want to find out more about the work, of course, the book is available open access. So very freely accessible to dive in a bit more to some of these questions that have been brought up. So thank you very much for your generosity and time. And yeah, we look forward to sort of hearing more from you throughout the day and the discussions. So let's give our appreciation to Dr. Stoyanova for an excellent keynote. Thank you very much.
And well, let me just thank Vladislava for kicking us off with a wonderful overview of positive obligations, something that we'll be coming back to in different ways during the course of the day. But for our first panel, we have three wonderful speakers from across the world of activism and academia. Nuala Toman, Dr. Gillian, Kane, and Caitriona Mackel. Each speaker will be speaking for about 15 to 20 minutes, so I will start to get your attention when we get up to 20 minutes, and may start waving these wonderfully colourful microphones around or doing something else to get your attention, just so we can keep on time and make sure we have a good 25 or so minutes for questions and answers at the end. So we're going to kick off with Nuala Toman, who's Head of Innovation Impact, Disability Action, Fellow of the Centre of Democracy and Peace Building. As a deaf and disabled person, Nuala has worked to close the gap between decision makers and deaf and disabled people. Nuala is author of Progress Towards the Implementation of the United Nations Convention on the Rights of Persons with Disabilities, UNCRPD, and The Pedagogy of Lifelong Learning. Nuala is a member of the All-Ireland Women's Forum and the Shared Island Forum, and a board member of the Northern Ireland Museum Council, Conradh na Gaeilge, and the Human Rights Consortium. So Nuala, over to you.
Thanks, Rory, for that introduction, and thanks also for the opportunity to participate in this conference. So disability is very much a human rights-based issue, and disability activists apply both the human rights model and social model to disability. And in doing so, we call for legislators and decision makers to be focused on the physical, social, attitudinal and legal and other barriers which prevent disabled people from fully participating in society. And Disability Action are calling for the dismantling of disabling societal obstacles and for the development of laws and policies which foster principles of inclusion and participation. So our goal is that disabled people are neither unwittingly or deliberately excluded from participation in public life, and that we are valued, supported and have access to services. And human rights law has an essential role to play in creating that kind of society. And this is why the unrealised commitment for a Bill of Rights for Northern Ireland has had such a severe and detrimental impact on the lives of disabled people, and kind of created circumstances in which disabled people have had to go to the courts or rely on advocacy, applying human rights models to secure positive solutions, which does happen, but in an increasingly restrictive society and in the context of our most recent political collapse. Some of that soft advocacy has become less effective because the barriers have become increased, and particularly senior officials and civil servants are less responsive to a challenge without turning to the courts. There was a time if you said the words 28E to a senior official, they would not implement a cut, and now they just do it anyway. So 28E is a provision within the 1998 Act that states that resources should be targeted on the basis of objective need within this jurisdiction. And it used to be enough to say that to stop a cut that would detrimentally impact on people who are on a low income or disabled people or children, and times have changed because these local statutory obligations are more or less being ignored daily. But having a rights-based society in Northern Ireland would sufficiently benefit disabled people. And in terms of positive obligations, I mean, we utilise the Human Rights Act, we utilise the UNCRPD, and in terms of local obligations, we rely on Section 75 of the 1998 Act and Section 28E. On the basis of demonstrating the importance of upholding the rights of disabled people within this jurisdiction. Disability Action are core participants in the UK COVID inquiry. Module 2C, the evidence for that has just recently closed, and we're awaiting the recommendations that will be made in July. In our approach to submitting our evidence and making our case, we applied the Human Rights Act as a framework within our evidence and put that to the inquiry, and the inquiry accepted that, and they accepted the human rights-based definition of disability and the social model. And through progression through all of Module 2, starting at the Westminster level, we saw a greater acceptance of the importance of protecting and upholding human rights. Now, we await to see what that means in terms of recommendations, but certainly the KSE to the inquiry made some really strong points. The evidence that we heard locally was damning, and was a damning indictment of how political dysfunction locally has undermined the rights of disabled people and many others. And we hope that those recommendations will point towards the need to uphold human rights in this jurisdiction and help us in some way towards the implementation of a Bill of Rights for Northern Ireland, because we feel that many of the things that happen to disabled people, such as being left starving, alone, isolated, without access to adequate housing, would have been avoided if we had had those protections that were promised through the Bill of Rights. So in terms of strategic litigation in the context of the Human Rights Act, there have been a number of recent cases that have been really interesting. So the Children's Law Centre have been quite active in terms of taking forward cases under the Human Rights Act in respect of disabled children. And there were two landmark judgments in February 2023 that showed that the EA had failed to meet their obligations under the right to education by failing to provide transport to disabled children. And those judgments have created space for more pressure to be put on the Education Authority to ensure that disabled children can access their right to education. And we're all too aware that there continue to be some of those dreadful cases reported on the radio. And in other areas, other parts of case law that stands out is there was a case taken in England quite a while ago where a woman had been given a place in a residential care home, and she had been promised that that was her home for life. There was then a process put in place to close that home, which she challenged under the Human Rights Act and won, and the promise for her right to a home for life was upheld. So it's just showing that there are opportunities to challenge decisions through the Human Rights Act. And also under Article 14 in 2017, DWP tried to remove access to high-level mobility for people experiencing mental distress. So the implementation of the regulations would mean that a person experiencing mental distress wouldn't have access to high mobility PIP. And that was challenged in the court, and it was recognised that sometimes people experiencing mental distress do need access to measures to promote independent travel. So that was upheld and those regulations were quashed. And again, just showing how there is potential by applying the Human Rights Act through the court to challenge poor decisions and decisions that breach the rights of disabled people. But in respect of the United Nations Convention on the Rights of Disabled People, and we use the term disabled people because the committee permit us to do so, like officially that is not what it's referred to, but because we apply the social model, that is why we refer to it as the Committee for Disabled People. So Disability Action complete the jurisdictional shadow report, where we review the progress within this jurisdiction against all of the articles within the NCRPD. Now, due to COVID, there is a backlog, and this jurisdiction and other jurisdictions within the UK were scheduled for review last year, and that was postponed. And instead, they decided to complete a follow-up inquiry under their optional protocol. The follow-up inquiry was to the inquiry that was taken in 2016 that concluded that welfare reform had resulted in the grave and systematic abuse of the rights of disabled people. So the committee then decided, because of time constraints, that that is where their action would be focused. And we prepared for a hearing in August, and it was a really important time for us in August because we had just found out the scale and direction of the decisions that were taken within this jurisdiction by unaccountable civil servants during the political collapse. So those decisions that were taken ignored our statutory obligations and had severe impacts on disabled people. And when we submitted our evidence to the committee, it was our hope that both the UK government and officials who would have been representing the executive would have had to hear our evidence on the impact of those cuts. But the UK government refused to attend that hearing, and that meant then that we did not get the recommendation that we wanted, because the Children's Law Centre had had the opportunity to put their evidence to the Committee on the Rights of the Child, and they had concluded that this harsh budget that had been put forward by the Secretary of State should be withdrawn. And we had hoped at that time that we would get something similar, but unfortunately we did not, and we were kind of left in a vacuum and thinking about ways that we could challenge these decisions. Now, in March, the government and executive officials did attend a hearing, and the committee concluded that those cuts have resulted in the deliberate, grave and systematic abuse of the rights of disabled people. And the committee also concluded that the recently reformed executive had taken no action to address those cuts in spite of being given access to additional resources. And that is a very powerful recommendation and conclusion. But unfortunately, in this jurisdiction, many of the recommendations are not taken forward. They're ignored. And while these obligations are internationally binding, they tend to be avoided within this jurisdiction, and that is some of the evidence that we put forward to the COVID inquiry as well, in terms of how politics and administration operates here in a kind of divisive way, and that division pushes disabled people out to the fringes. So we are in a situation whereby there's been little action taken to redress those issues. And as I mentioned before, the kind of advocacy approach taken forward, arguments based on breaches of rights, didn't work in those situations, because the feedback we were getting is that, actually we needed to do these to provide funding for these statutory services while not addressing other obligations that departments had. So you'll be aware that recently there have been 2 landmark rulings under Article 2 of the Windsor Framework, one in respect of legacy and one in respect of illegal immigration. And these rulings have really demonstrated the paramountcy of Article 2 of the Windsor Framework and its use in terms of protecting people's rights, and particularly in this jurisdiction. So what we have done in terms of disability action is we are seeking leave for a judicial review in respect of those cuts under Article 2 of the Windsor Framework, arguing that the cuts to services taken in that downturn period when there were no political institutions are in breach of Article 2 of the protocol, in that they have diminished the rights of disabled people, and that is under several European directives and under the Human Rights Act. So we have a leave hearing on the 16th of September, and then we will find out what the next steps are. And what we will say, our case is significant in that it is the first to be raised in this manner, and specifically in the context of the rights of disabled people. So we look forward to seeing how this will be tested in the courts, and really to see what Article 2 protections mean for the daily lives of disabled people. And we were fortunate enough to be able to proceed with this case because we're supported by PILS, which is the Public Information Litigation Service. And through that we have pro bono legal support. But not everyone has that opportunity because, PILS are an amazing organisation, but they may not be in a position to support every case. Now, our legal team in the COVID inquiry are a human rights-based firm based in London, and they raise cases like this day and daily, for everyday people. So a person in London can contact that firm and say, my rights have been breached, and they will advance the case, because there are better mechanisms. They're not perfect, but better mechanisms in place in England for individuals to challenge decisions through the courts. Our current legal aid system is not fit for purpose. It doesn't offer enough support for people or provide coverage for the wide range of cases or support strategic litigation in ways that the system has carved out in England does, because there are different mechanisms through which law firms can secure funding, on the basis of no win, no fee, and other opportunities that we simply don't have here. And there are also significant barriers for disabled people accessing pro bono support within this jurisdiction to make those challenges. Disability Action are working with a broad selection of personal litigants who simply do not have access to legal representation. And we would argue that that undermines their right to a fair trial in ways. And we look forward to the outcomes of the review of legal aid, and we'll be continuing to raise these issues with the Department for Justice locally. But ultimately, we feel that we wouldn't be standing here today with all of the things that had happened to disabled people throughout the pandemic, and the decision to end the services of disability action through those cuts, if we had have had a Bill of Rights for Northern Ireland, because there would have been greater clarity on the need to uphold people's rights. So we look forward to the day that that is actually completed. And thank you for your time.
Thank you very much, Nuala. And I think we'll wait until all three of our panelists have spoken to take questions at that stage. So thank you, Nuala. Our second speaker is Dr. Gillian Kane, a colleague of mine in the School of Law at Ulster. Gillian's research expertise is in the area of international migration law, and she works on the intersections between different international legal frameworks protecting migration. She's currently researching the role of international law in addressing human trafficking in the context of forced migration, including climate-related displacement. Gillian prior to joining us at Ulster, Gillian was a researcher at the Irish Centre for Human Rights, working with UN Special Rapporteur Siobhan Mullally. And before that, she finished her PhD at the School of Law in Queen's University Belfast. Gillian is also co-chair of the Human Trafficking Research Network, a research affiliate at the Refugee Law Initiative, and a trustee of CHAB-DI UK. Over to you, Gillian.
Thanks very much, Rory, and thanks very much, everyone, again. I am going to speak today, obviously, about Article 4 and identifying human trafficking in Ireland and Northern Ireland, and possibly how we can more effectively use Article 4 and the positive obligations that are in that to address and advocate for better protections for trafficked persons on this island. So broadly, going to be speaking about identifying and protecting trafficked persons, starting first of all with some of the gaps and issues, and then highlighting some of the possibilities under Article 4. And there's a lot that could be said about all of this. It's a big topic. I'm going to try very hard and stick to time. So what we're going to have today is really just the broad strokes, but hopefully it'll provoke some food for thought and to delve a bit more into the case law, and particularly in advocacy strategies. So in terms of what I'm going to cover, first of all, what is human trafficking, and then touching on some identification gaps in both Northern Ireland and Ireland, which of course are key to so many of the protections. And then, of course, looking at Article 4, what is its scope and what are the positive obligations that exist in relation to human trafficking. So starting out then, what is human trafficking? And I think it's important to start here because human trafficking is a term that can mean all kinds of things to all kinds of people, and the internationally agreed definition, and we'll see why that's important when it comes to Article 4, is found in the Palermo Protocol, Article 3A. So Palermo Protocol to the UN Convention on Transnational Organised Crime has been replicated in the Council of Europe Convention as well. Three main elements that make up trafficking: an act, so recruitment, transportation, transfer, harbouring or receipt of persons, a means, so threat or use of force, but you can also see other sort of less physically coercive means also there as well. And then the purpose, exploitation. It is, there are some examples of exploitation given, but it's a non-exhaustive list. The key is exploitation. And so where there's a combination of these three elements, there we have a situation of trafficking. As for the boundaries of these elements, there's certainly not quite universal agreement. So, for example, where do poor labour conditions tip over the scale into exploitation amounting to trafficking? Nevertheless, this definition can tell us a lot, and it most likely includes conduct that actually many domestic approaches exclude, and we'll see later why that's significant in terms of the scope of positive obligations. So moving on then with that definition in mind to some of the identification gaps in Ireland and Northern Ireland. And again, this is quite a broad overview, but in Ireland, there's been a sort of consistent problem with identification of trafficking. Ireland has been criticised by NGOs, treaty monitoring bodies, the United States Trafficking Persons Report, consistently for its very poor identification, you know, sort of things like 40 persons per year referred into their national referral mechanism. Very, very low. That being said, and I'll talk about it later, there is a bit of reform on the way which hopes to address that. But it has been a consistent problem south of the border, identification. North of the border, there are higher numbers. So comparatively to the south of Ireland, we seem to be identifying more trafficking, but it's still quite low compared to the rest of the UK, particularly in certain areas. One area in particular is young males. So our colleagues from IOM, and I've highlighted the study here, it's a very interesting study if you want to learn a bit more about it. Our colleagues from IOM have highlighted consistently that there's still never been any Northern Ireland male child referred into the NRM at all, so the National Referral Mechanism. That's despite more than anecdotal evidence that there's a lot of young males caught up in child criminal exploitation and forced criminality. So there's a disconnect between what we know is trafficking and what's happening. And it's against that context that I want to look at positive obligations as one possible way to maybe better address this problem. So Article 4 of the European Convention on Human Rights is where we're looking at for this. It doesn't explicitly address trafficking. We see there it says no one shall be held in slavery or servitude. No one shall be required to perform forced or compulsory labour. So the question is then, to what extent does trafficking, as we understand it, fall within the scope of Article 4? And there's been many developments in case law, and the situation that we're at now is that the Palermo definition is decisive. So example here from SM Croatia in 2020, which says the Grand Chamber noted that from the perspective of Article 4, the concept of human trafficking covers trafficking in human beings, whether national or transnational, whether or not connected with organised crime, insofar as the constituent elements of the international definition under the Palermo Protocol and Anti-Trafficking Convention are present. So in other words, the act means purpose definition is decisive. Right from Rantsev onwards, the idea that trafficking could fall within the scope of Article 4 has been consistently upheld. More clarity then in SM Croatia, which says it's the Palermo definition that is key. If it falls within the scope of that, it falls within the scope of Article 4, regardless of what provisions are there on the domestic level. So the obligations on the state relate to any conduct which falls within this definition. And so, in my view then, it's important that we have a clear and accurate understanding of what falls within that scope, and we'll come back to that. So within Article 4 then, there's been a number of positive obligations that have been enumerated by the court through its case law. But before I get to that, one thing I wanted to mention is, Rory spoke earlier about the various different ways in which the court has interpreted positive obligations, whether that's practical and effective. But one of the other things is about in interpreting the convention as far as possible in harmony with other rules of international law, and in particular for Article 4, the Council of Europe's Anti-Trafficking Convention and the views of Greta, the monitoring body for that convention, have been held to be quite important, and that has really influenced the way that the court has interpreted these obligations. In terms of positive obligations themselves, sorry, the first one isn't very visible on the screen. I would say there's 4 until recently, 3, but I think we will talk about how the court has added on this 4th obligation in relation to compensation. The first one, if you can't read it, the first 3 I've taken quotes from VCL versus the United Kingdom, where they did a very nice summary of them. So a duty to put in place a legislative and administrative framework to prohibit and punish trafficking, but it doesn't end there. Not just having the law and the framework is not enough. This operational duty, which I want to chat a little bit more about, the duty in certain circumstances to take operational measures to protect victims or potential victims of trafficking. A procedural obligation, so the procedural limit of Article 4, to investigate situations, and then I've put new here because, as far as I'm aware, I don't think we'd heard about it before the end of 2023. An obligation to enable the victims of trafficking to claim compensation from their traffickers. So everything from the law right through to after the fact. So we can see that from starting out from not seeing trafficking in the wording of Article 4, there's actually quite a lot in there that can assist trafficking. So, central to all of these obligations is identification. We simply cannot see compliance with these if trafficked persons are not being identified. And so our identification problem is a problem. And actually, I would say that facilitating identification is actually part of particularly the operational duty to protect. And so it matters how trafficking is defined and how identification is happening. So looking at the duty then to put a legislative and administrative framework in place. And again, this is quite broad. There's lots in this. I'm just going to focus on a couple of issues, north and south of the border, to highlight that actually having a legislative and administrative framework may not always be enough. Should it be effective as well? So in Ireland, what we see in the domestic law, and again, the broad strokes, the Palermo definition we do see broadly adopted in domestic law, but yet we've had this big identification problem. And so the administrative framework wasn't really working very well. And so what we've seen is proposed reforms. This criminal law sexual offences and human trafficking bill is expected, I heard a DOJ official from the south last week said it's expected to be law by the end of July before the summer recess. So I'm hoping that that is correct. It brings in a new statutory NRM, so the national referral mechanism for identifying people into it. And it will also add new competent authorities to deal with NRM referrals and add the possibility for NGOs to apply as trusted partners. So all of this should help to identify, and it shows that actually having the law and having the definitions in the framework isn't enough, but actually those proactive steps are needed. And so all eyes on Ireland in terms of those new positive steps that have been taken. In Northern Ireland then, we do have a legal and administrative framework. We do see higher numbers referred into the NRM, but I would argue that the deficiency here is actually in how trafficking is defined in law. We see here section 2.1 of the 2015 Act, which is actually just a copy and paste of the Modern Slavery Act, is saying that A commits an offence if he facilitates or arranges travel of another person, B, with a view to being exploited. So, okay, but what about the obligation under Palermo? Travel or facilitation of travel isn't central to that. There are many other acts that could take place. And so what we see in the domestic level is a restriction of the definition in Palermo. Now, true enough, the conceptual definitions or boundaries in the Palermo definition are contested, but I think we can at least agree that, act means purpose approach, like we see in Ireland, should exist in Northern Ireland. And I think there are some important implications there, because it could be that these legal and administrative frameworks, either explicitly through restrictive definitions or in other ways through inadequate mechanisms or even misunderstandings, can hinder effective identification and protection. And so key to all of this, I think, is establishing clarity on what precisely it is that we are identifying. And I think the question is then, what are we looking for? Or more accurately, perhaps in Northern Ireland, what are we not looking for? We should be looking for this. But as Foranger Bale says, sometimes we're not. And she speaks about, the image of a young victimised woman bound and gagged for implied sexual exploitation persists in the imagination, promotional material and reports of the anti-trafficking sector. She is presented as the ideal victim. And of course, there are people who have experienced this, but there are many victim accounts that deviate from this prescriptive path. In our context, and even with this definition in Northern Ireland, I don't even know if we are seeing identification always of the ideal victim. I would argue we're certainly not seeing much beyond that because of, how we understand and misconceptions of trafficking. But the state's obligation under Article 4 is to address trafficking in all its forms. The Palermo definition brings it within the scope of Article 4. And so ensuring that frontline service providers and state actors understand this is really, really important when we think about positive obligations. We need then to invest in the pursuit of understanding of what constitutes trafficking so that we can address it. So moving on then, and I just wanted to highlight that we may sometimes just be looking for this, but we should be looking for all of this if we want to comply with Article 4. Moving on then to the operational duty to protect. Dr. Stoyanova has talked a lot about this aware or ought to have been aware standard. When is the duty triggered? And we see this here in Article 4. When the operational duty to protect is triggered is when state authorities were aware or ought to have been aware of circumstances giving rise to a credible suspicion that an identified individual had been or was at real or immediate risk of being trafficked. And again, we see the Palermo definition being decisive. And so I do think the ought to have been aware standard is to be pointed out. The trigger for the state to take operational measures here is not just aware, it's also ought to have been aware. And we heard about some of the issues with that before, but I think one of the benefits in trafficking is the idea of we didn't understand what trafficking was is probably not going to stand up, in my view, because ought to have been aware, surely there should be an awareness of the act means purpose approach. So where this is the case, there will be a violation where the state fails to take appropriate action to move an individual from risk. Now, as for the type of operational measures, operational measures, but what are these operational measures? Again, the court has provided some clarity on this. So preventative measures could be about strengthening coordination at the national level, measures to discourage the demand. Protection measures, importantly, include facilitating the identification of victims and qualified persons. So again, identification really key here to these positive obligations. Where the state is aware or ought to have been aware about trafficking, there is an obligation to facilitate identification, not just that they were, but also real and immediate risk. And I think that asks a lot of questions for us about how we're addressing trafficking in the local context. Even more importantly, the court goes on in VCL to talk about how punishment can actually hinder some of these protections. So we see that the question of punishment is really important when it comes to trafficking for the purpose of forced criminality. In other words, should somebody be punished for a crime that they've committed as part of their exploitation? And we see here that, you know, we go into this kind of teleological interpretation of the operational duty. In VCL, the court reminding us that there are two aims of this operational duty. The first is protection from additional harm. The second is facilitation of recovery. And because of that, the court says it's axiomatic that prosecution of victims will be injurious to their physical, psychological and social recovery and could potentially leave them to be vulnerable to being re-trafficked in the future. The court stops short of putting a blanket bar on prosecution, but the emphasis then is on prompt and accurate identification so that an individual's status as a trafficked person can be to the fore in any decision to prosecute. And obviously, if someone isn't being identified and in the context of forced criminality, it's just straight arrest, prosecution. If there's not an awareness that that might be trafficking, then this obligation and these obligations are somewhat moot. And that brings us back to why that ought to have been aware standard, I think, is so important. Just keeping an eye on time to make sure. So moving on, then procedural duty to investigate. The only thing that I would say about this is that, again, there's a proactive requirement on the state, as we would expect with positive obligations. So the duty doesn't require a complaint from a victim or relative. Once the matter has come to the attention of the authorities, they must act of their own motion. So again, this onus on the state to be aware of what is trafficking, what are risk factors, and where might we see them, so that this proactive action can take place to identify and protect. And then, just very briefly, to end, compensation. So, very recently established by the court in Caitriona at the end of 2023, this idea that there's a positive obligation to provide for compensation. We see a comparison here to the Article 2 approach, and this idea that there's a need for protection in a post-trafficking experience. And we see here some of the reasoning, and this is a very brief overview, but it is a very interesting case. The possibility for trafficked persons to seek compensation in respect of lost earnings. We can see that this idea of restitution here, making good on harm suffered. And what also we see this idea of prevention, reducing the risks of falling victim again. So we can see how compensation now comes part of this. It's not just about legislative and administrative framework, operational duty to protect and investigate, but also a duty on the state to ensure that there are means for compensation from falling victim again. So a lot more that we could say about positive obligations and on identifying trafficking on these islands. Be very interesting to see how it progresses south of the border, because I think it's actually a really helpful framework that's going to be implemented, and we will see if that results in better identification. For the sake of time here, I'm just going to wrap it up and hope that we can continue, obviously, in the discussion later. But, you know, bringing it all together, what are we really saying? Well, I think key takeaways, Article 4, I think, is potentially underutilised tool in the domestic context when we think about human trafficking, and particularly those positive obligations. We see quite a bit of issues. I think that the positive obligations and an awareness among state actors of those obligations could maybe go a long way to influencing some of the policy and practice on this, and indeed some of the legislative provisions. The trigger, of course, is Palermo, and because of that, it is really important that we understand the act means purpose approach. There's a lot of conflating between trafficking and smuggling in the media discourse in the UK, and that might make us not understand trafficking when we do see it, and particularly those people working on the front lines. We see substantive and procedural obligations within Article 4. This is growing, so there may be more to come. Identification is central to all of this, and we do need to see improvement there. I think there are some implications for litigation and advocacy at the domestic level, because I do think these obligations have been underutilised in trafficking discourse, advocacy, litigation. So where to now? Well, I think we do need some conceptual clarification of the court's approach. I haven't touched much on that, but both within and beyond the European Court, there's a bit of conceptual misunderstandings on what constitutes trafficking, where are the boundaries, on the obligations within the court, on the relationships, for example, between forced labour and trafficking. We do need some of that. But I think what we also need at the same time is increased implementation of what we do know. We can't just push it all away and say, well, you know, it's all a bit contested. There are some clear obligations here, and there's a lot that we do know falls within the act means purpose approach of Palermo that isn't being effectively addressed. So while we pursue conceptual clarification in rooms such as this, I think there's a real need for increased implementation of what we do know. So I'll leave it there. Thank you very much for your attention and look forward to the discussion.
Thank you very much, Gillian. And then the final speaker on the panel is Caitriona Mackel. Caitriona is a PhD researcher with us at Ulster University. She holds an LLB in Law with Politics and an MA in Peace and Conflict Studies and an LLM in Human Rights and Transitional Justice. She has been actively involved in local politics and community relations project in a voluntary capacity over the last decade and is particularly interested in segregation, economic, social and cultural rights and reconciliation in Northern Ireland, all of which form the basis for her PhD project. So, Caitriona.
Thank you. Thank you very much for the invitation today. I'm speaking on affirmative action and housing inequality in Northern Ireland. So housing, and in particular social housing, is an intensely complex and sensitive issue, steadfastly entwined with broader social and political disputes over territory and identity. So against such a backdrop, tackling problems in the housing sector here can present a significant challenge. However, Northern Ireland's social housing sector is in the midst of a housing crisis, with unequal access to adequate housing, overcrowding, housing stress, homelessness, high waiting lists and long waiting times. So in 2017, the Equality Commission for Northern Ireland released its statement on key inequalities in housing and communities. And they noted that inequalities exist across all 9 of the Northern Ireland Act Section 75 equality categories. But there are 7 areas they consider to be the most pressing. These include longer waiting lists and times for Catholic applicants, limited access to appropriate accommodation for groups such as Irish travellers and migrant workers, vulnerability of harassment and attacks on the homes of ethnic minorities, migrant groups and members of the LGBTQ+ community, limitations on independent living with people with learning difficulties, and people with disabilities living in homes inadequate for their disability-related needs. However, this is not the full picture. And as the Equality Commission highlights, there are significant data gaps in relation to a number of equality categories such as gender and a lack of data disaggregation, particularly in relation to ethnicity, disability status, marital status and dependency status. So insufficient housing data substantially impacts the degree to which overall inequalities are assessed and monitored. But it also impacts the ability to monitor and evaluate individual actions taken by government departments and others to address housing inequalities. Both the Equality Commission, Northern Ireland Human Rights Commission and a range of NGOs acknowledge that little progress has been made to address many of the inequalities highlighted in 2017. And housing inequality in Northern Ireland remains an ongoing issue of concern. So these are just some of the statistics reported by the Northern Ireland Housing Executive for the year 23-24 to highlight the scale of the problem. So at March 24, total number of applicants, that is both families and individuals, on the social housing waiting list was 47,312, almost 75% of which are in housing stress. The number of applicants on the waiting list equates to around 86,000 people. During the year 23-24, 16,881 applicants presented as homeless, 18.4% of which did so on the basis that their accommodation was unreasonable for their physical health and disability-related needs. The number of applicants presenting as homeless equates to around 55,000 people, including 4,500 children. However, it's worth noting that very recent research by the Simon community demonstrates that the true extent of homelessness in Northern Ireland is not reflected in official statistics, and the number of homeless individuals stands closer to around 80,000 people. So, given that Northern Ireland's equality and anti-discrimination legislation applies to housing in the same way that it applies to other public services, then why then do housing inequalities exist? So despite the fact that discrimination and inequality in social housing is widely acknowledged as both a root cause and consequence of conflict, it's not commonly considered a legacy issue and does not typically appear in the discourse on dealing with the past. As a result, equality of opportunity and the provision of basic services in social housing sector is largely treated and viewed as a periphery issue to be dealt with by policymakers. Housing inequalities are also maintained and exacerbated by residential segregation. Residential segregation patterns, the presumption of no-go areas and the enduring sectarian tensions have the effect of fragmenting and limiting the wider housing markets, significantly impacting the housing choices and experiences of individuals from all equality categories. Opportunities to reform the housing executive have been consistently missed due to restrictions on public borrowing and the absence of political leadership, but housing reform is on the horizon. However, this is not likely to come quick enough or go far enough to supply the vast number of social homes needed to meet the current levels of housing need and demand. Section 75 could be a powerful tool to remedy inequality in housing, but it is widely underutilised, poorly enforced and routinely misinterpreted. Despite widespread consensus that the good relations duty under Section 75 is subordinate to equality of opportunity, it is often misapplied and used as a political veto to override equality imperatives. Additionally, and importantly, in comparison to those living in the rest of the UK, individuals in Northern Ireland are disproportionately affected by the absence of a justiciable right to housing, where the symptoms of housing crises are entangled with the legacy of a violent past. So around the world, vulnerable individuals and communities are significantly affected by the pronounced inequalities that arise where states treat housing as a commodity, as a vehicle for wealth and investment rather than a social good. So the UN Special Rapporteur on the right to adequate housing notes that too often violations of the right occur with impunity, largely because at the domestic level, housing is rarely treated as a human right. So there's no explicit right to housing, or indeed social housing, in the European Convention on Human Rights, and as such, no justiciable right to housing exists under UK domestic law. The absence of this right is significantly profound at the subnational level, particularly here in Northern Ireland, where grievances around the state's inability to deliver housing rights and basic services was a root cause of a violent conflict that lasted 3 decades. Despite often treading lightly on a right to housing under Article 8, the European Court of Human Rights has interpreted the term respect in paragraph 1 as implying a duty to take positive measures. So my research therefore focuses on how positive measures or affirmative action could be utilised to address new existing and persistent housing inequalities in Northern Ireland. So the concept of affirmative action is generally referred to in international law as special measures. The Special Rapporteur on the concept and practice of affirmative action defines it as a coherent package of measures aimed at specifically correcting the position of members of target groups in one or more aspects of their social life in order to obtain effective equality. While special measures are not mentioned in much of ISESCR, except in the texts of Articles 10.2 and 10.3, which provide for special measures to mothers before and after childbirth and to children, ISESCR does not preclude affirmative action from being taken on behalf of certain groups in society. And this has been upheld in a number of general comments by the Committee on Economic, Social and Cultural Rights, including General Comment number 5, which confirms disability as a ground on which special treatment can be justified, and General Comment number 13, which maintains that special measures intended to bring about de facto equality for men and women and for disadvantaged groups is not a violation of the right to non-discrimination. Additionally, the UN Habitat 3 programme and New Urban Agenda all stress that long-established human rights principles place an immediate obligation on states to ensure that deliberate and targeted measures are put in place to ensure all individuals, particularly those who are experiencing inequalities, disadvantage or exclusion, have an equal opportunity to enjoy their rights. So some early research included an article by Yuvrav Yoshi titled Affirmative Action as Transitional Justice. in which he argues that the inclusion of affirmative action within the transitional justice toolkit could better address the socio-economic consequences of the past. He argues that by fixating on a narrow set of mechanisms, transitional justice overlooks the role that affirmative action could play in bringing attention to structural inequalities and promoting the inclusion of excluded groups. And affirmative action is not a new concept in Northern Ireland. In 1987, the Standing Advisory Commission on Human Rights expressly recommended a regulatory framework to address inequality and underrepresentation in employment. The adoption of affirmative action measures in the fair employment legislation that followed, including robust monitoring, reporting and enforcement mechanisms, resulted in reduced religious discrimination, greater employment of underrepresented communities and greater employment integration. Although affirmative action was also considered by SACHR in their 1990 report on housing, it was ultimately rejected at that time out of fear of a hostile political and public reaction. The challenge of navigating housing in a politically sensitive and divided society resulted in a much softer approach and a failed opportunity to adopt statutory monitoring, reporting and enforcement procedures in the housing sector. The use of affirmative action to confront socioeconomic inequalities in the US, South Africa and Northern Ireland illuminate a range of pitfalls to be avoided and practical processes to employ in order to enable the effective implementation of affirmative action as a solution to the chronic inequalities that prevail in Northern Ireland's most politically, socially and physically divided sector. And the success of affirmative action in Northern Ireland's employment sector in particular demonstrates that affirmative action can work to address discrimination, inequality, exclusion and barriers to equality of opportunity when applied thoughtfully and robustly. So Section 75 was designed as a tool for the development of public policies and services that address the needs of all people, particularly those experiencing inequalities. My research outlines that Section 75 could be reinforced and thus utilised more effectively if legislative reform introduced a statutory obligation on public authorities to take affirmative action to promote and achieve equality. A positive obligation on duty bearers to take proactive measures, such as affirmative action, to address inequality and barriers to equality of opportunity in the housing sector is crucial. As such, Sandra Fredman's 4 ingredients, responsibility, participation, monitoring and enforcement are highlighted as essential to the successful implementation of affirmative action in the context of housing here. By restructuring existing and future housing policies to emphasise affirmative action, fairness and equality of opportunity, a range of affirmative fairness strategies such as fair housing supply, fair housing allocation and fair housing choice could enable the development of tailored measures targeted towards securing fair treatment and overcoming the social problems of target groups. Political and administrative will and commitment must be extended to embracing a statutory affirmative action-based approach to providing fair and equitable housing for all. If successful, this has significant implications for other unequal and segregated sectors in Northern Ireland and indeed for other societies attempting to overcome socio-economic inequality in the course of transition. Thank you for your time.
Thank you, Nuala, Gillian and Caitriona, for 3 very interesting presentations on different aspects of human rights in Northern Ireland and these jurisdictions and these islands and the possible role of positive obligations. So we will see if there are any, well, I have questions, but I will see if there are any questions from the audience. And again, maybe take them in groups of 2 or 3. So would anyone like to kick us off? We have Vladislava has a question over here.
Thank you. Naturally, I have a question for Gillian. So I understand the problem that you describe about not understanding what human trafficking is. And indeed, this is a definition that was adopted not to be understood. It was meant to be vague because it had to accommodate different ideological positions. But I think that there is the actual problem is that when it comes to identification, many of these procedures are part of criminal proceedings. And since they are part of criminal proceedings, the objective is not really to protect victims, but to prosecute and put somebody in jail. While the tendency has been that not to develop identification procedures that are separate from criminal proceedings. So I think this is really a core question. When interpreting the definition of human trafficking, as vague as it is and as problematic it is, we have to initially ask ourselves the question, why are we interpreting this definition? Is it for the purposes of criminal law? Is it for the purposes of human rights law? Is it for the purposes of identification of victims? And my understanding is that these things have been all mixed up, and that's why we have problems. Yeah. So I just, yeah, if you have, in the context that you're working, whether you see this as a problem and what you think about it. Thank you.
Thank you. Do we have any other questions? Question from Anne over here, Kevin?
Thank you to all three speakers. My question, and it's probably not a fair one, but I'll ask it anyway, is for Nuala. Nuala, you mentioned the Bill of Rights in your talk several times, and towards the end of your presentation, you said that you welcome the day that we have one. With the forthcoming general election, if Labour does win, will you be more optimistic of that day coming closer?
Is there and yes, Eilish at the back.
Thank you everyone. My question is, can each of you give us an example of effective lobbying, either in your own field or in one that you've observed? And the second part of my question is, can you tell us why you think you've met so much resistance in trying to bring about progressive change in this society, and perhaps relate it to us being a post-conflict society, if possible? Thank you.
Thank you very much for 3 or 4 questions there so far. So I think we'll give our panelists a chance to respond, and then we'll do another tour of the room. I think we'll take them in the order: Gillian, Nuala, and then Caitriona. Gillian.
Yeah, thanks very much. And thanks, Vladislava, for the question. I mean, the definition, yeah, I feel like we could have another symposium on just the definition of trafficking. And I think I probably don't see it as problematic as maybe some others, because I think actually its breadth is also its opportunity in terms of protection. If we're talking about a human rights approach, and you're right, I think the tension between the criminal law context from which it emerged and the human rights approach that we now have, like positive measures to protect, and you're right, identification then is often happening, like, is it the authorities, as soon as the authorities are aware? And, we have chatted, myself and colleague Sarah have chatted to even like, PSNI officers who say, like, their mindset is criminal law. So they're not always thinking about, it's not always first in their mind, oh, is this maybe a situation of trafficking? I think that is a problem. I'm not exactly sure how to address it, but I think I do see the breadth of it as an opportunity to think, well, how can we protect, like, victim or possible victim if we invest in a human rights focus? So, taking some of the positive obligations, particularly that operational duty to protect, I think, could we read into it that a state actually has a duty to ensure that non-state actors are properly trained to identify trafficking? So I'm thinking here about youth workers, about, health officials who arguably are state actors. So could we look beyond? I think we need to look beyond and I think the positive obligations, in my view, and I'd be interested to hear more of your views on this, do give the state an obligation to go beyond the criminal law approach. And I think that's why Article 4 needs to be brought into the trafficking framework, that it's not just this sort of criminal law, migration-related, strict focus, because that hinders our understanding, I think, of what trafficking is. I'm not sure if I've really answered your question or not, but...
When you interpret it in the context of criminal law, you cannot argue for an expensive interpretation. That simply undermines everything that we know about criminal law. So that's not the way to go. That's why you need to separate them.
Yeah, no, I think it's a really good point. And you're right, in criminal law, and I suppose that's the difference between, prosecuting and protecting, isn't it? And I know, obviously, you've written a lot on this. But yeah, I suppose the focus that we've been trying to take is on that not protection limb, because for a lot of people, the protection is more important than the prosecution. But yeah, a lot of the rhetoric, particularly in this country, is go after the traffickers, even though often that is smuggling that's being referred to. But that's another story. Shall I answer all the questions at once? Yeah. In terms of an example of effective lobbying. I actually think that what's happened south of the border in terms of trafficking and the new NRM, that has been many years in the making, and many NGOs have been really instrumental in that. And I think we're at a position where we're a couple of weeks outside seeing that be law. I would also say north of the border as well, some of the developments, I know I've been criticising the 2015 legislation, but there are positive aspects to it. So I think I would say it's been quite effective. In terms of resistance, I'm not actually sure if I think I see so much resistance in relation to trafficking or addressing trafficking. There's generally an open approach to that. I think it's probably misunderstandings of what's required. That is a problem more than resistance. But others may have other experiences in different areas. So I'll hand over to Nuala now.
Thanks. So in respect of the Bill of Rights, there's no doubt that the current Conservative government have been a significant blockage to the advancement of human rights, both within GB and locally. And there are many kind of examples where they've had a negative impact on the progression of peace and stability within this jurisdiction. If we think of kind of the collapse of the institutions and the challenge, to the protocol, the progress towards the Windsor Framework, there are a number of really negative examples. The positives around the Bill of Rights are all the work that was done in terms of the committee, which showed that there actually is cross-the-party support, but there is one party blocking that. The negative then is the interpretation by the NIO that there is a requirement for consensus for a Bill of Rights. That is not true. But society has changed, and there is now a more open debate and a wider acknowledgement of the need for a Bill of Rights. Now, I do think if we have a Labour government that is going to change. Not immediately, but I think there's a duty on all of us as activists and campaigners to continue to make that argument, because we really, really need it. I think when the evidence is published from the COVID inquiry, the extent of breaches of people's rights during the pandemic that could have been avoided if we had have had the Bill of Rights will be startling. And I know there's a lot of work that the Human Rights Consortium does to advance this. I've been saying to the NIO, just rip the plaster off. There are multiple examples where the UK government has progressed legislation here that is supposed to be contentious, and they've done it. It's like ripping a plaster off. The apprehension is greater than the outcome. So that's where I would like to see this go. In respect of successful lobbying, just in terms of disability rights, there are multiple good examples, but just one in the context of where we've been in the context of the political crisis. So the most recent political crisis was the most severe since the implementation of the Good Friday Agreement. Disabled people's rights were breached day and daily. There was a move to end disability transport. We were told that was it. It was over. There would be no more money. And that was one of the decisions that was taken when the institutions were not operating. Now, utilising things like Section 75, like the Human Rights Act, like the UNCRPD, and making those arguments around the negative implications and the breaches of those statutory obligations by breaching the right of disabled people to independent living. That cut was overturned and the service remains. But before that to happen, you need a minister that is open to hearing those arguments. And what we see in other departments is officials and ministers who are not open to hearing that these are in effect statutory obligations. And some of the evidence that has been published around the COVID inquiry actually shows the conservatism of our often well-meaning, but the conservatism of our local civil servants and actually the impact that they have in decision-making, which isn't always positive. And then there are ongoing challenges in terms of how our political system operates, because it limits cross-departmental working. I mean, the positives are obviously we're moving beyond conflict, but in terms of building cooperation, there's still a significant way to go, and hopefully we will get there.
Thank you, Nuala. And then Caitriona.
Well, I would say in terms of effective lobbying, particularly in relation to areas such as housing, grassroots activism is really important, alongside the work of NGOs and other housing organisations and charities. People power does a lot sometimes, and we see it quite a lot with movements in other places around the world, right to the city movements. There has been some successes with that here, with terms of the Markets Development Association. So I do think a kind of grassroots activism and people, if necessary, taken to the streets can be quite effective. In terms of meeting resistance to change, I would agree with Nuala that part of it boils down quite a lot to a lack of, I suppose, political leadership or courage on behalf of some political leaders. Part of the rest of it, particularly in relation to housing, would be based around presumptions and assumptions, of which there is a lot here, not just in political circles, but also in social circles. And I think one of the other things that actually is really important in terms of housing and resistance to change, particularly in and around the city of Belfast, in deprived communities and around areas around peace lines, is a loss of momentum around reconciliation efforts and how divisive and divided some of those communities still are today.
Thank you very much. Any more questions, Ivanka?
There is also Megan. Sorry, Megan. A quick question, if that's okay for each panel member. Thank you very much for very interesting presentations. Nuala, just going back to Disability Action and I being one of the core contributors to the COVID inquiry made me think of the COVID period and some of the emergency triage guidance that was given to hospital. There's been a lot of good research on how discriminatory these were and how they demonstrate that despite the social model of disability, despite all the fantastic work of the disability movement, including on developing the disability rights framework, ableism still prevails. This dominance of the disability normative society. I was wondering if you can offer some commentary on how useful a tool human rights are in relation to tackling ableism. To Caitriona, just a quick question about whether or not the tension, I would imagine, affirmative action may invoke in some people about overreaching and meddling with, I don't know, state business and whatnot, whether that would have an impact on limiting what proactive measures can be taken under that duty you outlined. And also if grassroots communities have a mechanism to feed into what would constitute a proactive measure. And very quickly for Gillian, what happens if a positive duty such as the the duty that imposes the duty to, sorry, what happens if a positive obligation, such as the one imposing a duty to investigate, is breached? As Dr. Stoyanova was saying earlier, what options do states then have, but also what options do individuals have to seek further redress?
Nuala, do you want to start?
That's a really interesting question, because in our evidence we use the term ableism and challenge ableism, particularly in the context of the right to life, against, in just directly in those circumstances that you have referred to, because during the COVID pandemic, disabled people were given DNRs without consent, do not treat, and were denied access to food and water within medical settings during the COVID pandemic. And we've challenged that through the whole framework of ableism. And what I'll do is, Rory, I will send you I'll send our evidence statement and our closing statement for each of the modules across module 2, which looked at political decision making, so you can kind of see how we have really argued that a sense of ableism persists through society that has really undermined the right to life to disabled people. At the time, we wrote to the Department of Health and we said that disabled people's right to life was being breached, and we asked for an ethical framework and we asked for a meeting, and we were thanked for the letter and told that an ethical framework would be put in place. And the then minister at that time did not meet with us, and senior officials had one meeting, and that is one of the issues that we had raised in the context of the inquiry. And our legal team has advised us at every opportunity to say that the outcome of the inquiry is to say there should be strategic, sustained and ongoing engagement with citizens, particularly women, children and disabled people, to ensure that decision making is ethical and in respect of disabled people challenges that ableism framework, which is all too prevalent.
Thank you. Caitriona?
Yes, so in terms of tensions with affirmative action, of which there are potentially many, it's one of the key things, I suppose, in my research has been paying close attention to some of the tensions that are very evident in places like the US and increasingly evident in places like South Africa, and trying to sort of carefully feed those back into how they would apply into housing here. So you definitely wouldn't be talking about quotas or things like that. You're talking more about using sort of softer affirmative action or proactive measures, outreach programs, or very much focusing on it being that sort of affirmative fairness approach, sort of in a very similar kind of vein to the employment sector here, which I suppose, at this stage is kind of a lot more sort of widely accepted and acceptable. In terms of grassroots feeding into those processes, well, I mean, I think for a start, grassroots activism feeds quite well into certain areas of socioeconomic rights here in terms of the work of NGOs and some other grassroots organisations. But participation processes are really important in any sort of affirmative action framework. We do have participative processes currently in organisations like the Housing Executive, although they don't operate, I suppose, in ways in which they necessarily should at times. So participation processes would be something that I'm recommending as almost being, I think, statutory in a way as a part of the operation of Section 75. And I also think that grassroots activism can help feed into all those other aspects of monitoring and enforcement as well too, in terms of making reports or different things and lobbying in terms of what's done and what's not done, if that answers the question. Thank you.
Yeah, so thanks, Vanka, for the question. I mean, to me, I suppose this is the same answer to where the state fails in any of its obligations, and particularly when it comes to positive obligations. And I think this brings us back to kind of where we started at the beginning of the morning with the zoomed out approach, where the state fails to investigate or take action positively, then it fails to prevent harm, you know, within the scope of any of the articles, and Article 4 is no different. So I think, you know, I think this is why this is also important, isn't it? Because you're saying, well, what options do individuals have? And in my view, and just as I was reflecting on it, there may be options to pursue a breach, whether that's domestically or when you exhaust domestic remedies at the European Court. But the harm's already done. If, for example, so I'm even thinking of something like VCL and AN, where the harm was already done. Yes, there was a breach held, but those individuals were already dragged through the criminal process. You know, the punishment had already occurred. And I know I'm talking about forced criminality, or, you know, that's where people can bring a breach, where people have resources or access to legal advice to get all the way to the Grand Chamber. The reality is most individuals in situations of exploitation, where it isn't picked up as exploitation, don't have very much option, and I think that is why the onus is on the state. You know, the court has been clear, and I know there are you know, all the conceptual issues that we do need to sort out, but there are things that are clear. That is, you know, when the state, the onus is on the state to ensure that there are systems in place to make sure that they do that. Where they fail to do that, then that's where the harm comes. And for a lot of people, I don't think there is much. I mean, on paper and in the books, there is access to an effective remedy, and, you know, all of that. But even where that does take place, there comes the harm, and the harm is there. So not a very hopeful answer, but I think that's why we need to get to grips with these obligations.
Thank you very much. Megan, sorry, we should have gone to you earlier.
Thanks very much. I have a question for Gillian, who's used to me asking her questions since she taught me in a course a few years ago. It's Gillian, I was wondering, could you say more about the current or potential divergences in rights between Ireland and Northern Ireland in rights and protection for trafficked people, maybe separate to the Illegal Migration Act implications, because they're currently being challenged? And if moves Ireland is making in this area are considered to meet international human rights standards, or is there still a way to go? Essentially, if Northern Ireland was to raise its standards, would North-South equivalence be desirable?
Connor also has a question there at the back. Oh, sorry, yes, go on.
Thank you. It's kind of a question for everyone, but also particularly for Caitriona, because she mentioned under gathering of Section 75 data, and in the area that I work in, and I think also Nuala mentioned it later on, so also in the area that Nuala works in, and probably everybody else, there's a consistent kind of either misunderstanding or misapplying of Section 75. And I suppose my question is, with regards to how Section 75 is or isn't being properly used, is it time for us to look at equality legislation that's separate?
Thank you, Elaine. And Natasha, I think you do.
Sorry.
Yes, no, I was just thinking about the same area as well. So I'm working for RAISE at the NI Assembly, and we are, you know, considering, you know, the gaps in equality legislation, and just even what we can learn from other jurisdictions as well, you know, whether that's from GB, from Europe, or from, you know, the international conventions. So I actually thought a lot about disability and some of those gaps, or have you come across anything that might be more updated that Northern Ireland could learn from?
Right, thank you. So we have a few questions, and I suppose we'll go back to the panel in the order in which they originally spoke. So Nuala?
And so looking at issues around Section 75 and equality, there's always a reticence around unpicking anything that is in the Good Friday Agreement. And I always feel that reticence myself. And that's why I suppose to look at the review of equality, really seeing that as sitting outside of Section 75, I think is really helpful. Because we are so behind in terms of equality protections with elsewhere, to the extent that the Chief Commissioner in the Equality Commission said that we're at risk of no longer being considered to be a developed country. And those words are stark. And you're entirely correct. Disabled people are really at the hard edge of this, and particularly around the access to goods and facilities, due to the outcome of the Malcolm case. So what we would like to see is, you know, a single Equality Act that builds upon the Equality Act 2010, but has more significant protections in that, and addresses the gaps in terms of age and disability and access to goods and services. I also think we need to be really clear about the need to protect women's equality, because there have been instances where maybe something has been challenged in the courts under Section 75 because there are negative impacts for women, and the court has discounted that because it is interpreting the Section 75 protections as being for gender. Therefore, if it is not impacted on both genders, then it didn't proceed, which is a really awkward ruling, you know, and that was in respect of a case that Women's Aid tried to take when they lost their helpline. So there is a really urgent need for us to have a proper equality framework. When we look at it, it's an enhanced Equality Act 2010 that Disability Action are arguing for, and specifically in terms of addressing those gaps that I've outlined. In regards of Section 75 specifically, there is a misunderstanding of what it is and what it does. Some of that I now feel is deliberate. I don't think it's being accidentally misunderstood. There was a time in about 2010 that it was being really well implemented in some departments, and that has changed. At that time, some departments were also embedding the Brown principles in terms of policy development and really looking at human rights. And all of that has changed, and I think it has been a deliberate change. I mean, most recently, there were the issues that the Committee for the Administration of Justice were raising with the Department of Finance in terms of they had agreed changes to the equality scheme within the Department of Finance that were then removed during the political downturn, and they're now being put back in. And I think, so my analysis is that there is a deliberate disregard, and where we need to get to is that Section 75 is at the forefront of policy and legislative change, but is also applied to budget decision making along with 2080, and that there is a human rights framework applied to budgetary decisions locally as well, to protect services and people.
Very much, Nuala. Gillian.
Thanks very much, Megan. So, you know, I was just reflecting on, I suppose, from that very brief kind of dip into the reforms in Ireland, and also that one section in the Northern Ireland legislation, it might have given the impression that, you know, Ireland is really great and Northern Ireland is really terrible, and that would be wrong. So I do want to correct that. I think what I was given there was maybe an example of, in Ireland, maybe one of the issues I see is in around actually implementing the law in terms of the mechanism, and in Northern Ireland, you know, problems with the definition. But actually, practitioners and academics in Ireland, and actually was speaking to a few of them last week, are looking with awe at our great identification stats. So I think that's an important piece of context. Northern Ireland is doing really well on this. I was pointing out maybe somewhere where I think we need to have improvement, and how that's important in terms of positive obligations. So I definitely wouldn't want to not give credit where credit's due. We are all hopeful about this new legislation in the south, that it will start to see those numbers come up, because, you know, this new NRM, putting it on the statutory footing, bringing in more what's called competent authorities to be able to, you know, identify and through the system. But then this provision of NGOs as trusted partners. So any NGO can apply to be a trusted partner and can help to refer people into the NRM. And this kind of comes with a little bit what I was saying earlier in the question that Vladislava asked, in the sense of, you know, how can the state take positive action to ensure that more identification happens? And when we go beyond a criminal law approach, you know, and widen it out, I think what Ireland has proposed is actually really interesting. Of course, none of this is signed off yet. Hopefully it will be, and none of it's implemented yet. So in terms of the question of compliance with international law, like on the books, I think probably yes. But of course, we've seen from this positive obligation things that just having a legal framework isn't enough. So, you know, the proof of the pudding is yet to come with that. But I think people remain positive about it. But certainly, you know, in terms of equivalence, I think, yes, probably equivalence is a good thing. I think if you're experiencing harm, you know, in Dublin or Belfast, you know, we're all bound by the European Convention, so that is a standard that, you know, grasps everybody. And I think it's a good tool to ensure that, you know, protection does remain the same across the border. But I'm sure there will be nuance as well. And I'll leave it there for the sake of time.
Thank you. And Caitriona, last word.
Yes, so just on that misunderstanding and misapplying of Section 75, you know, I think one of the things that comes out quite clearly, particularly from interviews I had with my research participants, is very much agreement with the lines of what Nuala was saying about the fact that it is often deliberately misinterpreted and misapplied in many ways, and also not necessarily in a deliberate way, but that misinterpretation and misapplying also stems back to the Equality Commission as well, with too much of a focus on the good relations duties over equality duties. I do think some form of separate equality legislation is probably needed. I would agree with Nuala. It does need to be separate from Section 75, not just to protect anything or avoid unpicking Good Friday Agreement, but also because whatever comes in needs to really have teeth. And one of the things that's really important as well too, particularly in the housing sector here, is the involvement of the private sector, which we can't really enforce under Section 75. So while the housing executive is unable to build, while housing associations are restrained in other ways, while there's no public money to pay for housing, we rely quite heavily on the private sector, who also basically get away with not fulfilling different things under local development plans, and more needs to be done to have private sector regulation. So I do think that something does need to probably be brought in and separate though from Section 75. Thank you.
Right, well, thank you very much. That was a fascinating panel and great questions and lots of interesting discussion that hopefully can continue over lunch, which I understand is waiting for us just outside, and continue on into the afternoon. So we'll have lunch break now and reconvene at 2 o'clock. But can I just ask you to thank our panelists again in the accustomed manner? Thank you.
You're all very welcome back. We have three very interesting speakers. The first speaker is Alan Brecknell from the Pat Finucane Centre. Alan is an advocacy support worker for the Pat Finucane Centre, which for those of you who do not know, is a non-party political anti-sectarian human rights NGO, which supports bereaved families and survivors of the Northern Ireland conflict. And indeed, Alan's father was killed in a UVF gun and bomb attack in 1975. Alan's father was out celebrating the birth of his daughter. He was born just 2 days earlier, and Alan at the time was only 7 years old. And as a result of that, Alan has been involved in supporting and advocating for other victims after approaching the Pat Finucane Centre himself and trying to seek help for his own case, which resulted in the Brecknell judgment before the European Court of Human Rights, which Alan will speak to in his presentation. Alan also sits on the Victims Forum in a personal capacity, and he has extensive experience of engaging with other stakeholders on legacy and victims issues. He recently completed a BSc in psychological trauma from Queen's University, and he's also a former student of Ulster University, when he got a postgrad diploma in human rights law and transitional justice. So each speaker has 20 minutes, so I'll hand it over to you, Alan.
Good afternoon, everyone, and thank you for the invite today.
even though it says on my bio that I do this fairly regularly, I still get very nervous whenever I'm up doing things in front of people that I don't know. So I suppose I'll just quickly go through this. What I'll cover is the background, who the PFC are, sorry, the Pat Finucane Centre, who they are, who I am, a bit about Article 2, the right to life. 2 case studies, as Anne's already alluded to. One of them will be the Brecknell judgment from the European Court of Human Rights. And then the last slide is just about current challenges in relation to legacy moving forward. So the Pat Finucane Centre, the PFC, that's probably how I refer to it throughout all of this, provides advocacy, advice and support to victims and survivors of the recent conflict. Obviously named after the murdered human rights lawyer Pat Finucane. We have 4 offices, one in Armagh, one in Belfast, one in Derry and one in Dublin through our sister organisation Justice for the Forgotten, who work with the victims of the Dublin and Monaghan bombings, but also a number of other cross-border attacks. Work with approximately 220 families bereaved as a result of state violence, loyalist and Republican violence. However, the majority is from what would be classed here as the Catholic nationalist Republican community. We undertake extensive research of open source materials, newspaper libraries, declassified government documents, in Prony here, in Kew in London, where the British National Archive is, and in the National Archive in Dublin. We also take part in oral history and commemorative and memorialisation events in relation to some of the families that we work with. We don't provide health and wellbeing support as it is known within the victims and survivor sector here. We would refer clients on to the Wave Trauma Centre for anyone who may need counselling or other psychological support. We've campaigned on legacy and victims issues, most recently concerns around the Legacy Act and the establishment of the Independent Commission for Reconciliation and Information Recovery, which I will refer to as the ICI or IR, if I can get it right. We have engaged across the years with various investigative bodies examining conflict-related cases. And for example, the RUC, whenever it was still in place, then whenever it became the PSNI, we had engaged with the Serious Crime Review team and the Historical Inquiries team, and more latterly the Legacy Investigation branch of the PSNI, the Coronial Service, the Police Ombudsman's Office. So, Article 2, I'm not going to go through. I'm sure everyone is very well aware of what Article 2 is, but I suppose what Article 2 does do is imposes a positive duty to protect life, a negative duty not to take life, and a procedural obligation on states to investigate the circumstances of a death to determine whether the right to life has been contravened. Article 2 of the duty to protect life. So in relation to state actors, the court must assess all the circumstances of the use of force when determining if deprivation of life was justified or not, including actions of state agents, the planning and control and training. In the McCann judgment, case examined the legality of the killing of 3 members of the Provisional IRA by British security forces in 1988, widely known as the Gibraltar shootings. The European Court held the use of force not absolutely necessary. Means used were disproportionate to the objectives, i.e. saving lives of those in Gibraltar from a terrorist attack. They could have apprehended the suspects at the border. They didn't consider the intelligence could be wrong, and the use of the SAS, who are trained basically to kill, and the procedures and planning, there was a failure. So the court found that there had been a breach of Article 2 of the Convention, the duty to protect life. No breach of procedural obligations to investigate, however, as an inquest had satisfied this obligation. Again, furthering on the duty to protect life in relation to non-state actors. So there's a positive obligation here to take preventative operational measures to protect an individual whose life is at risk from the criminal acts of another individual, but the obligation does not impose an impossible or disproportionate burden on the authorities. For the positive obligation to arise, it must be established that the authorities knew or ought to have known, which we've already heard about this morning, at the time of the existence of a real or immediate risk to the life of an individual
or individuals from a criminal acts of a third party, and they fail to take measures within the scope of their powers which judge reasonably might be expected to avoid that risk. I'll just give a couple of examples here from a number of recent reports from the Police Ombudsman's Office. In 2022, the Ombudsman's Office reported on the UDA murders in Belfast in the 1990s, including the Ormo Road Sean Graham bookies attack. It looked at 11 different murders and a number of attempted murders. So it basically said there were legitimate and justified concerns by the families regarding collusive behaviours by the police with loyalist paramilitaries. No evidence that the police had received any information which would have allowed them to prevent any of the attacks, but there was a failure to warn two individuals of a threat to their life. Failures led to the arming of paramilitaries, failures to investigate, the continued unjustifiable use by Special Branch of informants involved in serious criminality, including the murder and the passive turning of a blind eye to such activities. Failures to warn of collusive behaviours are common features within Police Ombudsman's reports. Another example is the 2022 report into 19 UDA murders in the South Derry area, including the Greysteel massacre, and the 2014 report into the killing of RUC Sergeant Joe McCann, where the head of Special Branch had been told that Mr. McCann's life was in danger. So in relation then to the procedural obligation, what is an Article 2 compliant investigation? These possibly more readily known as the Jordan requirements outline what constitutes an Article 2 compliant investigation. It needs to be prompt, effective, engaged to next of kin, open to public scrutiny, independent, and initiated by the state. No particular procedure must be adopted, varies, depends on the circumstances. Families in Northern Ireland rely on this judgment to argue for Article 2 compliant investigations. An example, McCaughey and others, the ECHR found that there had been a procedural violation of Article 2 caused by excessive delay in the inquest proceedings caused by the quality and timeliness of the disclosure of materials. So Mackel and others. Group of cases brought by families alleging inadequacy in investigations of the use of lethal force by state agents from 1980s and 1990s. Cases involve deaths from security force operations or in circumstances that raise suspicion of collusion between security forces and loyalist paramilitaries. In 2001, the court found a number of violations of procedural obligations: lack of independence of investigating police officers, lack of public scrutiny and information to victims' families on reasons for decisions not to prosecute, defects in the police investigations, limitations on the role and the scope of inquest procedures, absence of legal aid for the representation of victims' families, and delays in the inquest proceedings. The response from the UK government was to put in place a package of measures to remedy the procedural breaches of Article 2 that include the Jordan requirements. The package of measures and the Committee of Ministers Scrutiny and Oversight. This package has evolved and changed in subsequent years to address the procedural obligation. Namely, there were legacy inquests until fairly recently. The establishment of the Historical Inquiries Team in 2005 to review / investigate conflict-related deaths. The Historical Inquiries Team was disbanded in 2014 following a critical report by Her Majesty's Inspectorate in 2013, which found a lack of Article 2 compatibility. It was replaced by the Legacy Investigation Branch of the Police Service of Northern Ireland. There are also Police Ombudsman's investigations, again, up until the 1st of May this year, which I'll come back to. Civil actions, again, up to the 1st of May this year. And ad hoc call-in review investigations from outside police forces as a result of legal challenges from families and information becoming made available, or new evidence becoming made available. So it's Operation Canova into the agent within the IRA stake knife. Operation Denton, which is an investigation into the Glenanne series of cases. 120 plus killings on both sides of the border, including the attack where my father was killed. Operation Mizzenmast, the killing of Jean Smith Campbell in 1972, and Operation Turma, where 3 RUC officers were killed in a bomb in Kinnigo embankment outside Lurgan in County Armagh in 1982. So the PFC's role as an advocate. For over 30 years, the PFC have been supporting families engaged in these investigative and review processes. We've compiled a list of questions for families. We've engaged with the other agencies, such as the Ministry of Defence, on behalf of the families. We've scrutinised and critiqued reports from statutory agencies, identified and support witnesses to come forward and give evidence, attended court hearings and legal meetings with or on behalf of the next of kin or families, undertaken research to assist investigations, including providing materials that have resulted in new inquests being granted by the Attorney General and complaints being completed by the Police Ombudsman. We've also engaged with Garda Síochána in relation to killings and attacks in the south of Ireland. We've engaged with ex-paramilitary groups in the past, although in recent years that has diminished somewhat. We have previously, as I said, engaged with the RUC, the Serious Crime Review Team, the Barron Inquiry, which was set up by the Dublin government to look into the Dublin and Monaghan bombings. We've prepared submissions for the Committee of Ministers, re the UK's ongoing failure to meet Article 2 procedural obligations to investigate. So I'll just go through 2 quick case studies here to give a sense of what we do and where it falls within positive obligations. This case study is probably better known as the Good Samaritan bombing in Derry, the IRA bombing which killed 3 civilians in the Craigan area of Derry in August 1988. The family lodged a complaint with the Ombudsman, claiming that the RUC failed in responsibilities to protect their father, Sean Dalton's right to life. The findings of the Ombudsman's report in July 2012 were police were very aware of the threat of the bomb, its location and their own duty to protect the public and maximise the safety of the police and security staff involved in any response. No contingency was put in place to protect the public from the bomb, and whilst the responsibility for the murders remains with the bombers, there was a failure by the police to protect the lives of the local community who were in such a real and immediate danger. The RUC failed to do all that it could reasonably be expected of them to avoid a real and immediate risk to life, which they knew about. Whether by today's standards or those of 1988, there was a failure to uphold Mr. Dalton's right to life. Under Article 2 of the European Convention on Human Rights, which states everyone's life shall be protected by law, it is my opinion, and this is the Ombudsman talking, that police failed in their responsibilities to uphold Mr. Dalton's right to life, and that he substantiated that finding. Also found that the police failed in their duty to investigate the death, and that's just a link to the report at the bottom there if anyone wants to look at it in the future. So the family complaint, the complaint was police failed in their duty by knowingly allowing an explosive device to remain in a location close to where the public had access in order to protect a police informant. However, the findings of the Ombudsman were I found no evidence that the police failed to act in order to protect an informer. However, a number of retired police officers identified by this investigation as likely to have had knowledge that would assist the investigation declined to cooperate. The Police Ombudsman doesn't have compellability powers in relation to retired police officers. The family applied to the Attorney General for a new inquest, which was refused. So this eventually went the whole way to the Supreme Court. A thorough report has been compiled after 8 years' work by the Ombudsman. In our view, this satisfies the Article 2 procedural obligation upon the state in circumstances where the police misconduct is the only remaining issue. In circumstances where prosecution or accountability of the perpetrator is no longer live and where the state collusion has been ruled out, we think that such civil claims could potentially meet the Article 2 obligations. That's what the Supreme Court found in the case. Since Mr. Dalton's death occurred more than 12 years ago, they went on to say, before the Human Rights Act came into force, the Attorney General's decision not to order a further inquest into his death cannot be challenged under the Act. So the role that the Pat Finucane Centre played in this was the PFC drafted the complaint to the Ombudsman with the family and supported them throughout the 8-year investigation and the legal challenges that followed, including accompanying them to the European Court of Human Rights. Unfortunately, during this process, 2 siblings have passed away. The family have now lodged a case with the European Court. So, in relation to Brecknell v the UK, on the 19th of December 1975, there was an attack on Donnelly's Bar in Silverbridge in County Armagh. 3 people were killed: my father, Patrick Donnelly, and Michael Donnelly, not related, and 6 others were seriously injured, including my aunt and my uncle. A number of other fatal attacks around the same period. There were investigations led to arrest and conviction of a number of RUC officers, including Sergeant John Weir, for the murder of William Stathearn in 1978. However, most of the cases did not lead to prosecution. In 1999, John Weir, whenever he was released from prison, makes various allegations about security force involvement in a number of murders, including those at Donnelly's Bar and the Dublin and Monaghan bombings. At this stage, both the Garda and the RUC start investigations into these allegations. There are serious delays in the Northern Ireland investigation under the remit of the RUC from 1999 to 2000, then the Serious Crime Review Team of the PSNI 2005, and then the HCT in 2000, or sorry, PSNI, SCRT 2003, HCT 2005. Number of domestic legal challenges initiated, inadequacy of the investigation. So the complaint that was lodged on behalf of my mother was basically that the UK had failed to provide an effective official investigation into the circumstances of her husband's death after allegations were made in 1999 by John Weir as to RUC involvement in invoking Article 2 of the Convention. So the court's assessment was basically in relation to independence. The RUC lacked the requisite independence in the early part of the investigation, therefore violation of Article 2 at this stage. ECHR satisfied that the court was satisfied that the PSNI were institutionally distinct from its predecessor. They went on then to look at promptness. The RUC took up inquiries without undue delay. It may have dragged due to difficulties interviewing Weir and a large number of other cases being reviewed. However, I would make the point that we were able to find John Weir, who was living outside the jurisdiction. Justice Barron was able to find John Weir, and we were able to interview him, as was Justice Barron. However, the RUC weren't able to. In relation to effectiveness, the court was not convinced that there had been any significant oversights or omission. The key traceable witness had been interviewed and the available evidence collected and reviewed. And in relation to that, the RUC had written to the Garda to say that they weren't able to interview all the people that was on a list that they had provided, saying that one of the individuals was dead. However, the Garda then had to write back to them to say, contrary to that, was the person not only alive, but was also living with one of the other people who had been interviewed by the RUC. So, not sure how effective that was. Public scrutiny and involvement of the next of kin. It would appear that the police did make efforts to meet with the family members from 2000 onwards, and there's correspondence with the family's representatives, and there were, but there were also numerous correspondence asking for those meetings. So, the ruling and the next steps. The court took the view that where there was a plausible, so this is probably the most important thing that comes out of the Brecknell judgment, where there was a plausible or credible allegation, piece of evidence, or item of information relevant to the identification and eventual prosecution or punishment of the perpetrator of an unlawful killing, the authorities were under an obligation to take further investigative measures. And I've attended numerous court hearings here in Belfast, and the judges and the barristers and everyone refer to Brecknell in this notion that there's new evidence or some form of new evidence has come forward, and that's why a case needs to be reopened. The case and the PFC's role, as I've already said, it's one of 120 linked cases known as the Glenanne series, including the Dublin Monaghan bombings and the Miami show bans. There was a judicial review taken by the Bernard family, which led to the establishment of the Operation Denton Review, which was originally under John Boucher and is now under Surrey and Livingston. The HET had promised the families that they would receive an overarching report that linked all the cases together as opposed to individual reports, and that was never published. So that's what the judicial review is about. It's also subject to continuing ombudsman investigation, and the PFC continue to support the families on both sides of the border. Anne Cadwallader's book is stating that it's not a statement denial, it's lethal allies. And Sean Murray's documentary Unquiet Graves have helped the families tell their story. We've also been involved in a number of commemorative events across the years, and most recently with the 50th anniversary of the Dublin and Monaghan bombings. And as I said, we signpost people for health and wellbeing support. So finally then, the current challenges. Tension between the Human Rights Act and the European Convention, the critical date, which is in the Dalton judgment, and it basically says that the Human Rights Act only becomes effective 10 years before it comes into force, which brings all the Article 2 issues back to 1990. The vast majority of killings here are obviously long before that period of time. Northern Ireland Legacy and Reconciliation Act 2023, investigative measures that form part of the package of measures stopped by the unilateral decision by the UK government to bring legislation, largely opposed by victims and survivors, the Northern Ireland Human Rights Commission, all Northern Ireland and Republic of Ireland parties, the Irish government, that should say the Labour Party, not the Labour government, international human rights community. Legal challenges in relation to that, there are a number of judicial reviews, and there was a hearing just over this last number of days in relation to the Legacy Act, finished yesterday in the Court of Appeal here. Multiple individual cases have been lodged by individual families to the European Court, and the Irish Government has also lodged an interstate case with the European Court, and the PFC, along with a number of other NGOs, have sought permission to intervene in relation to that case. So the impact then on families, most families have no confidence in the ICRIR, so families are left with nowhere to go. Labour Party's public commitment is to repeal and amend the legislation, but we'll have to see. They have to win the election first, and we'll see what happens then. That now means that there's legal confusion around how we deal with the past here. Delay the age profile of most victims and survivors, like my mother, thankfully is still alive, but she just turned 91 there a couple of weeks ago. So I suppose that gives a demographic, or the age demographic of the people we're talking about. I would also point out that over 50% of the deaths here happened before 1976. So again, we're going back nearly 50 years at this stage. Uncertainty, cases have been stopped. Will they be resumed at some stage? Lack of justice, unanswered questions, emotional turmoil that leads to intergenerational trauma, and there was a number of mentions of reconciliation or whatever here earlier as well. You know, we're passing on trauma from one generation to the next, and the societal impact. So the damage, and just I would finish off by saying there's a very good two-piece article by Anna Bryson and Louise Mallender, which points out where the Legacy Act actually damages reconciliation as opposed to working towards it. So thank you.
Thank you very much, Alan. Our next speaker is Elaine Crory. Elaine is the Women's Sector Lobbyist at the Women's Resource and Development Agency. She's also a Specialist Advisor to the Westminster Women and Equalities Committee inquiry on violence against men and girls. She has a background in adult education and holds an MA in Politics and International Relations and a BA in Politics and History.
Thanks very much. I'm going to speak a little bit, first of all, about what a women's sector lobbyist is, because I realise that's a very strange job title. It's considered quite normal in the sector I work in. It's not a regular job title. There's been somebody in this role since 2008, and I am the sixth person to have this job. And I suppose part of the reason of the turnover is it's a little bit like a colleague said earlier, banging your head against a wall, or pushing a gigantic rock up a hill. The way I explain it to my 7-year-old is I argue with politicians And she assumes I win because I'm the kind of person who likes to win an argument. A lot of the time you don't. What you're trying to do is persuade decision makers, be they politicians or something else, to make decisions that benefit women and girls generally. And a huge part of my work in the last number of years has been around violence against women and girls, which is what I'm going to mostly talk about now with regards to positive obligations. So I hope you can read this from where you are. It looked nice and big on my screen. It looks quite small when it's up there. So the value of the concept of positive obligations kind of can't be overstated. But in this presentation, I'm going to talk about what that can mean, what it does mean in practice, what it doesn't mean in practice. And at that point, I'm going to return to the general state of the women's sector in Northern Ireland as distinct from elsewhere, and then what it could mean, because I like to end on an optimistic note. So the idea of placing an obligation on the state to protect the rights and freedoms that are protected in the Convention on Human Rights is significant. And it's particularly significant in the current political atmosphere we're in, where it seems, seems is maybe a generous way of putting it, it seems as if the currently existing government are very eager to ditch as many of those obligations as possible, and particularly very eager to ditch the ones to put what they consider to be an undue burden on them to protect people's lives. But it's been a concept that's been used in various ways around what I've called VOG, that's violence against women and girls, and gender-based violence generally. And it has been used while not necessarily being the basis of the argument behind bringing in certain schemes. And those include what so-called threat to life notices. These are, and that's distinct from what happens here, where perhaps if you get a threat from a paramilitary organisation, it's communicated to you by the PSNI. These are different, but they're fundamentally the same principle, which is when there's a credible threat to the life of a woman or girl as a result of a domestic abuse situation, the police services are obligated to find them somewhere new to live, to issue that we believe it's a credible threat and remove that person. Those are generally more used in England and Wales and not really used in any meaningful way here. There's also what I've called DVADS scheme. It's also known as Clare's Law. That stands for Domestic Violence and Abuse Disclosure Scheme. It has two branches to it: the right to know and right to ask. And the right to ask is pretty simple. I, as an individual, or any of us as individuals, can go to the police and say, I am concerned about this person that I'm in a relationship with, or that my sister or friend or neighbour is in a relationship with. Can you tell me if they have anything in their history that would show up on disclosure? So then the police do their check and tell you whether or not there's anything to be concerned about, in theory. Sometimes they won't give you a disclosure at all. Maybe you don't live with the person, or the person that you're inquiring about isn't in a domestic relationship, as in they don't share a home. Or maybe they did share a home and now they don't anymore. And even if they have children shared in common, there's a feeling of the rights of the individual have to be, the individual who's being inquired about has to be balanced with the rights of the person to a disclosure. So you will get a very limited disclosure, or sometimes no disclosure at all, which shows that it's not a rights-based kind of scheme where the rights of the potential victim is considered. It's centred around the rights of the potential offender. And I say potential because sometimes these people are, sometimes they're not. There's the most important one with regards to positive obligations, though, is the other branch of the DVAD scheme, which is the right to know. And this empowers police forces to approach a person and tell that person something about the history of their new partner in a relationship. It's very difficult to get a clear picture of how often police are, well, we know the numbers of how often they're using it, but we don't know really when they're making the judgment call to say it's not right to approach that person, they haven't breached a certain threshold. And when you ask for disclosures from police about this, you get a very sort of mixed bag in terms of detail. They will give you the numbers of times they've approached somebody, the numbers of times they've been approached and who they've said yes to and who they've said no to, but they won't really tell you what they're including or not including. The PSNI, we lobbied them, going back to the role of women's sector lobbyists. One of our jobs is to, like I said, argue with decision makers. We lobbied the PSNI about their implementation of the DVAD scheme last year. They've done a review of it, they've found some faults in it, and are hopefully amending that. Long way to go though. But the other part, and probably the most important part of the way in which it's kind of been incorporated into domestic law and domestic practice, is the duty to investigate. Now, the duty to investigate, I'm going to return to using an example of a case in just a second, but the duty to investigate means the duty on the state to investigate when something has already happened. So it's not as kind of a proactive thing, it's about redress for individuals who've been wronged. Now, these are, they have said, you know, like I say, this is how it could be used and how it sometimes is used, but it's also how it's not used. It's very patchy in practice as to how reliable this information is, or whether you'll get any information at all, like I've said, with the DVAD scheme. Also true for the threat to life notice. It has to cross a very high threshold before the police will take that step. They're generally underused, by which I mean there isn't a huge amount of public awareness about things like the DVAD scheme, even a good number of years after it's come in. So people often don't know until after their case is over and they've been through perhaps something like Women's Aid and they've come out the other end of an abusive situation that they could have found that information earlier on. Bigger, more important issue is they concentrate quite a lot of power in the hands of police forces. And since the topic is violence against women and girls, it doesn't take too many leaps before you think about the fact that, as well as the very famous Sarah Everard case, where her murderer and rapist was a police officer, there's also things like David Carrick, who was serially abused multiple women over a period of years while working at the Metropolitan Police, and probably countless others too. So given too much power to police forces, not only empowers those abusers within the police, but also it adds to that thing where it's not really accessible by citizens. It's entirely in the hands and of police, and they can make their decisions quite cloaked and dagger from the public perspective. And more, as I've mentioned, they provide redress. They don't really initiate change in institutions, the way in which positive obligations are interpreted in British law, but I'll come back to that in a bit. And they tend to be used by individuals or small groups of individuals who were wronged by the same person, rather than on a collective basis, and I'll come back to that as well. So I want to look at this particular case that I've mentioned that was used to kind of, it was seen as a watershed. The heading I've put up there is a big deal, because that was the way it was framed. It was going to be a huge deal because now, after a particular case was taken to the ECHR, there was a judgment that there was a duty on British police forces, in this case the Metropolitan Police in London, to investigate properly to cases of, in this case, sexual violence. The person mentioned there, War Boys, was known as the Black Cab Rapist. He's believed to have raped over about 100 women, but we're not entirely sure. He drugged them as well. This case was taken by 2 of his victims, not all 100, 2. And that's how usually these cases go, and that's kind of standard. But it was hailed as a precedent. It would turn around how police approach cases of sexual violence. It would open the doors to, I believe the Sun newspaper called it a flood, open the floodgates or something like that. I've got it quoted on the next slide, to loads of other cases where a person maybe did not get a conviction in court, and then they request their information and they make a claim through this, through the ECHR, that their case was not properly investigated. Has that actually happened? No. So that's the difference between practice and theory. The War Boys case was successful in arguing that the nature of his offences breached Article 3 of the ECHR, and therefore the lack of investigation breached the duty to investigate properly. It's not uncommon, however, for victims of domestic and especially sexual violence to report the wrong that was done to them to the police, and to hear nothing for a long time and then be told the investigation isn't going any further, or to be passed to PPS or equivalent of PPS, depending on your jurisdiction, and be told it's not going to be prosecuted. That happens more often than not. For every crime that's reported to police, only a very small fraction actually result in any kind of court action at all. Are all of those a case where they're not properly investigated? Probably not. But are some of them? Maybe so. This is what they were fearing when they actually, this is the phrase the Sun used, a lawsuit bonanza. This is what they were fearing when that War Boys case was judged in the AHRC. They were fearing that every individual who complained of sexual violence or domestic abuse and did not get the result that they wanted in court, or never got near a courtroom, would immediately appeal to the AHRC and say, look, my Article 3 rights were violated, the police did not investigate properly, or the prosecution service did not make the right decision. I would like to have this looked at again. This is not what's actually happened at all in practice. I've said here investigations are often cursory and justice not forthcoming. I mean, people do get letters in the post telling them that they've decided not to proceed with a case, and it transpires that the person that they've alleged harmed them has not even been interviewed, let alone arrested, let alone anything else. So it does seem to be, obviously police have particular criteria, but it does seem to be that at least some of those cases would be in the same category. But that's not really how it's panned out. There's a bigger argument about the duties of the state with regards to sort of entire communities, as in proactive things, and I'm coming to that in a second. But this case here is a kind of an example. If you have the right legal support and the right advice, you can find redress. And that's what happened in the War Boys case for those two individual victims of his. The other 98 approximately never got this, and the average person doesn't. What happened was an organisation or an institution called the Centre for Women's Justice stepped in, and they took on the case. Now, the Centre for Women's Justice is based in England. I believe it covers England and Wales. It may cover Scotland. I should have checked whether it covers Scotland, but it certainly doesn't cover Northern Ireland. And they take on cases on a kind of pro bono basis to where they think they have grounds. They're extremely experienced lawyers, extremely experienced international human rights lawyers as well. They have the kind of financial resources to take a case all the way to the end. The average Jane does not. And very often the average Jane has found the whole process quite traumatising and doesn't feel the ability to go looking for that kind of support, even if it was out there. Additionally, there's the issue that, quite simply, even if they did, there aren't really the mechanisms without a little bit of kind of public movement behind it. In this case, the War Boys case was extremely widely publicised, and there was momentum, let's say, behind that case. That's pretty rare when it's just Jane accusing John of something that happened in a private room. It never really gathers that kind of public momentum. So like I said, the Sun talked about a lawsuit bonanza. All the women in the world who've ever been to a courtroom will be taking the government to the ACHR. It hasn't happened. It probably won't happen, short of enormous sums of money flowing into the women's sector and lots of experts stepping forward offering their expertise, which doesn't seem likely. I mentioned before, in my job, I'm trying to advocate for the women's sector in Northern Ireland. It's never really been in a worse situation financially than it is now. That kind of money that exists in the Centre for Women's Justice isn't really abounding here, and the kind of resource isn't either. What I am going to do now is end on a slightly more optimistic note. I'd call this in an ideal world, right? It's a kind of what you could do, potentially, to incorporate domestically into domestic law positive obligations with regards to violence against women and girls. And that is to say, you're not brought to court on an individual case. You decide that you're going to take these steps independently. So I've offered lots of suggestions, and these are just my suggestions. There's no kind of, there's no huge piece of work behind this. So a positive duty to protect people, including adequate training for police on new legislation and prosecution services with robust standards for investigation. So one of the things that has been found again and again, I'm thinking of another case actually in England where a woman complained of being stalked. The police didn't believe her or take her seriously. In fact, they charged her with making malicious complaints. And then she was murdered by the man who was stalking her. That kind of matching the training and the understanding up with the actual law in order to make the law actually useful. And then also expecting robust standards for investigation, because surely an investigation into a case like that would have shown that this person was a real danger, or at least that she wasn't lying. Provision of adequate and funded shelters. This is to say, not reliant on charity, but funded by the state. And safe housing for those moving on from shelters. One of the reasons that there's inadequate shelter provision is because we don't have public housing to move people on from when they're ready to leave shelter accommodation. That's a particular problem in Northern Ireland where all our shelters are always full. Provision of legal support. And that's the kind of thing I'm thinking of when I talk about civil legal aid, for example. If you want to get a non-molestation order, it won't cost you to get a non-molestation order, but if you want a solicitor to represent you in the court, that will cost you. So if you're being stalked or you're being abused or harassed by an ex or an abusive partner, and you want the state to protect you, you have to pay for a lawyer to get that protection for you. That's the kind of thing that would proactively or could proactively be taken so that certain things are not within the realm of you having to pay. Provision of adequate court resources. By that I mean 2 to 3 years to get to the end from a complaint of violence against women and girls to an actual end of the court trial. Not to mention things like having to share a waiting area in the courtroom with the person you've alleged abused or harmed you. Provision of medical assistance, robust medical assistance, including counselling, not, for example, we've had counselling services here that initially used to offer 12 sessions, that was cut to 8 sessions, that was cut to 6 sessions, and nothing for under 16-year-olds. That kind of rolling back of services for people who've been harmed and that the state did not protect from harm and now isn't helping to recover. And breathe. The last and probably most important one, because it underpins all of the others, is a kind of a cultural shift with regards to how the justice system and the state thinks about violence against women and girls. Because it is framed very much as a thing that happens to an individual. This thing happened to Jane, John did that thing to Jane, maybe, but not really about as something that almost operates like the weather. Like you can't avoid it, even if it isn't happening to you right this moment because you have an umbrella or you're indoors. Ultimately, you live in a world where you're subject to these things. And the state could do much more. In fact, there's been, in the last couple of years, both in Northern Ireland and in Britain, a number of pieces of legislation come in around violence against women and girls to help people find redress. But it's focused very heavily on punishment of perpetrators, on the justice system itself, and on giving powers to police. It's not really focused on preventative measures and so forth. And I will finally say, I've got 1 minute and 5 seconds left. Northern Ireland is soon to get, apparently, the first ever violence against women and girls strategy that we've ever had. It's got a focus on prevention. It's one of the most important things, it's probably the most important thing I've ever worked on in my professional life. We spent put a lot of work into it. About 50% of it is focused on prevention. We'll see how it's implemented because that's another part of the story. But what I will say is that kind of approach needs to be taken across the board, but also it needs to be resourced. It's not good enough to put in preventative measures and then ask charities and NGOs and arm's length bodies and everything else that's being cut to the bone to do that work by pure will and a little bit of magic. It has to be funded by the state. It may stop short of everything I'm asking for here, but it's the correct kind of direction of travel with regards to positively protecting women's rights. So thank you.
Thank you very much, Gillian, and thank you also for defining your job title. We all know what her job title means now, so thank you. And our last speaker for this panel is Professor Rory O'Connell. Rory has already introduced himself this morning, so thank you, Rory. I don't need to do too much. Just to add that Rory has a long list of publications, too long to cite. I'll just cite his latest book, which is entitled Europe, Law and Democracy, and it's available in all good bookstores. So over to you, Rory.
Thank you. And I believe you can even buy it on an installment plan on Amazon. Unfortunately, academic books are very expensive. And I congratulate Vladislava on having her book open access. It's really wonderful. But anyway, I want to talk about the idea of effective political democracy and positive obligations. And I'll talk a little bit about context, some background then on the law in relation to the European Convention on Human Rights and Democracy, the topic of the book that Anne kindly mentioned, and then highlight 3 areas, maybe 2.5 areas, we'll say 3 areas where positive obligations may play a role in deepening an effective political democracy. The context is that across Europe, there are good reasons to be worried about the state of political democracy in many countries. You can look at Hungary, where Prime Minister Orban proudly talks about fostering an illiberal democracy. You can look at Poland until recently. You can look, of course, at Russia, now excluded from the Council of Europe. You can also look closer to home. There are quite a few issues with the state of democratic practice in the United Kingdom. I think particularly under the Johnson premiership, that particular government had issues with the idea of political accountability, which is central to an effective political democracy. You see that most dramatically, I suppose, in the prorogation case, where the Supreme Court unanimously ruled that Parliament had been unlawfully prorogued during the debate on Brexit. But you see that also perhaps in how the Conservative government has introduced changes to voting procedures in England and Wales. So there's issues about the state of democracy across many countries in Europe, including, of course, in the recent European parliamentary elections. What does the European Convention on Human Rights have to say about all of this? It does have some things to say about it, maybe not as much as you might think, for reasons I'll explain. But it does have some things to say about it. I would say that when we look at the European Convention on Human Rights, and when we look to see how can it help us with fostering an effective political democracy, one which demonstrates the hallmarks of pluralence, tolerance, broad-mindedness that the European Court talks about in its Article 10, freedom of expression jurisprudence. There's some reasons to be cautious about what we can expect from the Convention and the Court. First of all, I think, and it's already been hinted at in different interventions, we have to be a bit realistic about what change we can expect from courts anyway. There are limits to what courts and judges can do in order to solve political problems. And rightly earlier, we had some of our speakers refer to the need for activism and civil society to be engaged in ensuring that there are effective political reforms. I think, secondly, there is also an issue with the European Convention on Human Rights and the European Court of Human Rights. And Vladislava, I think, referred to this in a number of different points. The court is aware that it is a subsidiary body. The main obligation for protecting human rights in the European Convention on Human Rights falls on the states. The court's role is subsidiary. Subsidiarity has been written now into the European Convention on Human Rights, which is a fairly recent development. But even before subsidiarity was written into the European Convention, we had a notion that there was a margin of appreciation available to states in terms of how they implemented the different rights in the European Convention. In domestic parlance, we might say that there is a margin of discretion, or there is an element of deference in terms of how states can implement the rights in the European Convention on Human Rights. And that margin of appreciation, that element of deference, tends to be wider, tends to be more expansive in certain areas. Socioeconomic issues, for instance, very, very wide margin of appreciation usually. Issues about the right to life, unlawful use of lethal force, very narrow margin of appreciation. And then design of political institutions. Generally speaking, the Court of Human Rights says that we have to have a wide margin of appreciation for different reasons, because countries have different political traditions, they have different political contexts, and they are trying to, in their political systems, balance different competing, often antagonistic principles between, do we have a proportionally, a sort of representative parliament, or do we have an effective parliament? And these things are not easy to reconcile. And a third challenge with what the European Court does in relation to the protection of an effective political democracy is also in the very limited notion of democracy in some ways that we find in the European Convention on Human Rights. In some international treaties, the International Covenant on Civil and Political Rights, for instance, we find a relatively expansive reference to the right to take part in public affairs, the right to take part in the government of one's country, and the language of the Universal Declaration of Human Rights. When we look to what the European Convention has to say about political rights, it's much more narrowly focused on the idea of having elections in which the free choice of the people is expressed in the election of a legislature. So it's rather narrowly focused on electoral politics. It's very narrowly focused on the choice of a legislature. In fact, implicitly, it's even focused just on one chamber of the legislative body. The wording in the relevant article of the European Convention is framed in such an odd way as to protect institutions like the House of Lords, for instance, which is clearly not a democratically elected body. So there are some limitations, some caveats when thinking about what can the European Convention, what can the European Court of Human Rights do about the state of effective political democracy. That does not mean that the court has done nothing. On the contrary, since the late 1980s, we've seen a burgeoning case law on issues relating to political democracy in many different countries across Europe. And often they deal with cases involving the formal exclusion of people from the political process. So we have cases dealing, for instance, with laws on people subject to mental incapacity being banned from voting in the political process in Hungary, and the European Court finding that those sort of blanket bans are incompatible with the right to vote. We find a slightly unusual body of case law from Italy, all dealing with a principle in Italian law that if you're declared bankrupt, then you lose your right to vote, and the European Court has found all of those to be in violation. We have some interesting cases involving Bosnia-Herzegovina, which of course also has a power-sharing system of government, a different type of power-sharing system of government from what we are used to here, but nevertheless a power-sharing system of government. And the way in which the Bosnian system works for the election of the three-person presidency and for the election of the Bosnian upper house of their parliament, you can only be a member of the upper house of the parliament or a member of the three-person presidency if you belong to one of the three constituent peoples in Bosnia, which has the effect of excluding people who do not identify as being one of the three constituent peoples. So you have people who may be Jewish, may be Roma, or may prefer just not to identify as a particular category, who have successfully pleaded that these provisions in the Bosnian system breach the right to vote or to run for election and the principle of non-discrimination. A lot of the case law so far has been about those sorts of formal exclusions, right? And of course, you can include the long-running, very long-running at this stage, saga on the prisoner disenfranchisement voting laws in the United Kingdom. where the European Court of Human Rights also held that the formal exclusion of all convicted prisoners from voting rights was a breach of the right to vote in the European Convention on Human Rights. But all of that deals just with formal exclusions. This is where positive obligations start to come in. What can positive obligations do to move beyond a body of case law that just deals with formal exclusions and try to make a political process that is more effective and inclusive and egalitarian? And there's 2 or maybe 3 areas where positive obligations so far kick in this regard. One is that maybe we can make arguments, and we've already started to see arguments come to the fore, saying that there must be positive obligations on the state, on public authorities, to ensure that people, especially people from disadvantaged or vulnerable groups, can participate effectively in the political system. And you might think here of different groups that would be subject to different sorts of vulnerabilities or different forms of exclusion, if you prefer. But we do already have some cases dealing with people with disabilities, notably in a case from Slovenia, where a number of applicants argued that they hadn't been allowed to vote on conditions of equality with everyone else because there was no assistive technology so that people with certain sight impairments could vote in secret without having to reveal their vote to another person. Yeah. And the Court of Human Rights gave an interesting judgment. It ultimately found against the applicants, but it did say that, yes, in principle, there must be a positive obligation to provide some sort of assistance in these sorts of situations. Gillian earlier referred to the fact that the European Court of Human Rights sometimes relies on other international treaties in order to interpret the obligations in the European Convention on Human Rights. And this is one of those cases where the court looked to the Convention on the Rights of Persons with Disabilities to say, look, we have to take into account how do we make the right to vote, the right to participate effective for persons with disabilities, and accepted that there must be an obligation to help correct certain factual inequalities that preclude certain groups of people from voting. In the particular case, this goes back to that idea of a margin of appreciation. This goes back to the fact that the court sees itself in a subsidiary role. The court pointed out that, well, actually, Slovenia has taken some steps in order to make sure people are included in the electoral process. It has provided physical access through the use of a ramp. It allowed people with disabilities to visit the voting place of vote a few days in advance to familiarize themselves with the setup. So it had taken some steps, and the court wouldn't go down the route of saying a particular type of assistive technology has to be made available, because it said this is all the thing about balancing different interests that we heard about this morning. It could be costly. There could be issues about security involved in the use of such technologies, and we don't have any sort of European-wide consensus or standards in this. So the court wouldn't go as far as the applicants wanted, but still recognize that in principle there is a duty to provide some sort of assistance. The second type of case, which is interesting in relation to positive obligations and the state of an effective political democracy, especially in the context of concern about far-right political parties or parties that play to or make use of the tropes that you find in far-right political parties. It relates to the issue of hate speech during electoral campaigns. Here again, the European Convention on Human Rights in its text is a lot more conservative than some other international treaties. So other international treaties, such as the Convention on the Elimination of Racial Discrimination, the International Covenant on Civil and Political Rights, have specific provisions saying that hate speech or incitement to racial hatred and discrimination should be prohibited. We don't have that in the European Convention on Human Rights. Right? We do have a provision that implies that extremist, racist speech isn't protected speech, isn't protected expression. but we don't actually have a formal clause that explicitly says that this sort of expression must be prohibited. How does the court then deal with that? What the court has started to do in a case Aksu in Turkey is say that in some instances, certain types of expression, which racist expression or other forms of hate expression, affects people's private life. Right? Article 8 of the European Convention on Human Rights talks about the right to respect for one's private and family life, and this has often been given a fairly expansive interpretation by the European Court of Human Rights. As we heard this morning, it's one of those articles, for instance, which grounds certain protections for what we might otherwise call environmental rights. And what the Court of Human Rights says that some types of extremist hate speech will interfere with your right to respect for your private and family life. And in Aksu, there was an issue that the speech in question was found in a dictionary or an instruction manual, which referred to Gypsy and Roma, and then had a language like pejoratively, this is used in a negative sense, right? So the Aksu case, no violation was found. But in more recent cases from Bulgaria, in these two cases from Bulgaria, we have instances where politicians had used fairly extreme language, one in relation to Roma communities, accusing Roma being criminals and similar tropes, and another politician using extreme anti-Semitic Holocaust denial level types of expression. And here the Court of Human Rights found that there had actually been a failure on the part of the state to respect its positive obligations to protect individuals from violations of their right to respect for their private and family life under Article 8. So there is some scope to think about how the Convention may ground obligations in relation to the use of certain types of hate speech, not just during elections, but in this particular case, during elections. Though I should caveat that in the Bulgarian cases, the language was really extreme, right? Really quite blatant extremist language. A third type of case, which is more difficult, so hence 2.5, is that maybe we can think about obligations, positive obligations on the state to ensure that the dissemination of information, that the broadcast media respect principles of pluralism, that we do not have a concentration of media resources, broadcasting resources in the hands of one state provider or in the hands of one private economic actor. So here, this is much more tentative because most of the cases concern Moldova and the unusual position of a state emerging from a communist regime in which there was an extreme limitation on state broadcasting. But the court does talk about the obligation of the state to ensure the pluralism and diversity of the media. So again, with the cautious approach that the European Court often takes, we may not be at the point where we can imagine people taking action against the UK government for failing to regulate the activities of, say, GB News. But there is some scope for arguing that there's a positive obligation on the state to promote diversity in the news broadcasting medium. And we can imagine other positive obligations. There's a very interesting one currently making its way through the court from the United Kingdom, Bradshaw in the UK, where a member of parliament is arguing that there should be a positive obligation on the UK state to investigate effectively allegations of external Russian interference with the Brexit referendum. I personally think the European Court of Human Rights will try to avoid that question any way it can, but it is an example of the kinds of arguments that people can make and hopefully try to get some redress in the European Court of Human Rights. So, thank you.
Thank you very much, Rory. So like the previous panel, I'll now open it up to the floor for a set of questions, and then we'll ask each speaker to respond, and then take another set of questions if you have further questions. So, anybody want to ask a question, comment? Yes, thank you, Natasha. Sorry, that'd be for the mic, sorry.
Just a small observation, but whenever you were speaking about the role of maybe the European Court of Human Rights referring to the international conventions, so then I was starting to think of how do those international conventions apply to Northern Ireland? Is there quite a hierarchy in that? Would they have more influence now than the ECHR?
Yeah, thank you. Yeah, and
Thank you. I have a question for Rory. I'm not sure if I can frame it in the best way, but I'll try to frame the question. So it's positive obligations at the end of the day, as I have understood them, they're really about the role of the state. How much state do we want in our lives? And there might be a threshold where too much positive obligations will imply too much state. So do you have such a concern, and do you relate this somehow to positive obligations? Because they are expensive, we know that. I already mentioned they compete all the time with other positive obligations. But at the end of the day, they imply too much power, might imply a lot of power for the state. And this came also up during the previous presentations. The police will have too much power. It is about putting more power on the state authorities. So how then do you reconcile this with the idea that we are liberal democratic societies? And again, I know that I'm struggling myself with this, how to address this. Yeah.
thank you. Any other questions? More questions for the other two speakers?
I don't mind.
I have one. I'll abuse my position as chair for Alan. Alan, you mentioned the infamous Legacy Act, and I was on my way down this morning. Henry Ben was on the radio, station Radio Ulster, and he referred to, he was asked if Labour get into power and following the general election into government, in terms of their promise within their manifesto to repeal the Act. But he then talked about keeping elements of the Act, such as the body that's been established in terms of information retrieval. So I would like to just to hear your perspective on that. So, Rory, do you want to answer your queries, please?
Yes, thank you. So yes, I suppose the short answer about international conventions, there is a hierarchy in that it's fairly clear, and there's a good reason for this, that UK courts will pay a lot of attention to the European Convention on Human Rights and the case law of the European Court of Human Rights, because by law it's part of the Human Rights Act, so the convention rights are part of UK law, and UK courts must take into account the case law of the European Court of Human Rights. Very few other international human rights treaties are made part of domestic law in that way. So it's much rarer for UK courts to refer to other international treaties. It's not impossible and it's not unheard of, and there have certainly been some references, I suppose, especially to the Convention on the Rights of the Child, and some other treaties like the International Covenant on Civil and Political Rights, for instance. Sometimes this is in cases where the rights, say in the International Covenant on Civil and Political Rights, overlap with rights in the European Convention on Human Rights anyway, because they are both concerned with civil and political rights. There have been some more efforts to get the UK courts to take a look at the Convention on the Rights of the Child, including in the Supreme Court case on the two-child limit for child tax credits, which was ultimately unsuccessful. There have been some suggestions back when the likes of Lord Kerr from Northern Ireland was on the Supreme Court. He did sometimes indicate he would like to go further and come up with a new common law rule that would allow him to invoke international human rights treaties that the UK had ratified, but that was very much I think pretty much a solo effort on the part of Lord Kerr. And so that isn't the state of UK law as a matter of what the courts do. Yeah. Yes, and absolutely, yes, Vladislava, I do have the same concern that, especially when I think about some of those last cases about the Moldova case and whether or not we really want to be having discussions about positive obligations on the state to ensure there is pluralism and diversity in the media. In one sense, yes, but there's the countervailing concern that can you trust the state? Yeah, and yes, so that is a genuine issue, absolutely. I, however, also think the European Convention is clearly not the US Constitution. We're not in a case where in the US Constitution there's a sense, at least among some interpreters of it, that any government is always a necessary evil at best. It's reasonably clear from the European tradition and the European Convention on Human Rights that we shouldn't concede. The state is potentially dangerous, but it's also important. In fact, not the entire doctrine of positive obligations, but a big thing about positive obligations is that who can individuals rely on to protect them from private powerful actors, be they economic actors, be they institutional actors like the churches, who can step in to protect individuals from those sorts of powerful actors. The best answer to that, and it's not maybe an ideal answer, is, well, actually a democratically accountable state is what we have to rely on in order to protect us from abuses by those kinds of powerful actors.
Sorry, that's why the link with democracy is so important, which links to your presentation, I thought. Because if it's not, then we cannot rely on it. Yeah. So in this sense, I think generally in human rights law we have issues understanding the role of democracy, but we can discuss it.
Liam wants to follow on from that question as well, please.
Yes, thank you. And mainly because I was also thinking and mentioned in the presentation the risk of giving kind of too much power to police forces in particular, but the state generally, but particularly the police. And it's not just because there are stories of the state abusing power, even if there were no examples in the history of the world of a state abusing power, which of course there are, it would still be a worry anyway, just on principle. But I think we have to also see the power that the state has in not doing things, if that makes sense. Like the amount of power that's bound up in failing to investigate, for example, somebody's case. Is it greater than or lesser than the power, than an excessive power? It's not something you can quantify. It's not something you can put on a weighing scales. And I don't know the answer. But I do think it's definitely one where, when considering it, we also have to consider the power bound up in the ability of the state to say, no, that's not for me to get involved, and that's between private citizens or similar. And I think particularly in my area of work, that was the default position for millennia, where the state kind of stood back and said, well, you got married to him kind of thing. And just what that meant for individuals. So yeah, I don't have a nice answer, but I do think there's yes, it is bound up with democracy, absolutely, in that you can get rid of, theoretically, the government if they overstep. But it's still not an easy answer, even knowing that you have that safety valve.
Okay, thank you. Just before, let Alan answer the question.
I was listening to Hilary Benn myself this morning coming down the road, and I thought a lot of his interventions in relation to anything to do with Northern Ireland here, whether it's the health service or whether it was Casement Park or whether it was legacy, was a bit evasive. He's obviously a politician, and he's obviously a politician who thinks he's going to be the next Secretary of State by the sounds of things, as did my presentation. But in relation to what he had to say, like, I mean, that there was a commitment, and his leader made the commitment up in Queen's that they would repeal the Act. It's in their manifesto that they will repeal the Act. And he did say, I will repeal the Act, but, and he sort of went, oh, where's this going? I understand his rationale to a degree, where he says the ICIR is operational. You have a chief commissioner, you have an investigative commissioner already in place, you have lots of other people already employed. Why would you throw out the child with the bathwater? I think the difficulty lies in where the genesis of the ICIR come from. And it come from a commitment from the last Conservative government to British Army veterans to say that we will not drag you through the courts, that we will not put you through investigations in the latter years of your life. I think that was a commitment that was badly made, because if someone has broken the law, no matter who they are, they should be made accountable to the law, or at least have the investigated, or at least be investigated sufficiently. I think where we should be going with it is that we had the Stormont House Agreement, where you had two separate bodies. You had an investigative body and you had a truth recovery body. What the ICIR has done is mould the two bodies together. And anywhere where you're offering amnesty for this notion of reconciliation, and I think that's a huge step to actually take in this instance, in my opinion, is wrong. I think we should be going back to the Stormont House Agreement and make it Stormont House Agreement Plus, where you have an investigative body which allows people who have questions to go to it, and where you have a truth recovery type body, where someone can come forward and say, well, I believe X, Y, and Z happened. I was involved in X, Y, and Z. But that then has to be investigated in some way to find out whether it's truthful or not. I could come forward and say anything. If it's not being investigated, if it's not being verified, it's meaningless. And we've seen during the Ballymurphy inquest, where there were a number of allegations made by certain individuals, and the inquest basically said that didn't happen. But that was only able to happen because it was an inquisitorial, which is a word I can hardly ever say, process. And that's where you have to have that sort of process. So I'm not sure where he gets, I'm not sure how he gets to the point that he wants to get to.
Thank you very much, Alan. Sorry, do you want to ask your question now?
Essentially, I'm contradicting what was put forward by that lady over there. I don't know her name, sorry. Essentially, if the convention has been breached, the police, the state, already has the powers, and what we're looking them to do is enforce the convention. There's nothing wrong with that.
So just a couple of reflections, really. So every time I hear a presentation on legacy, it really shows me how much human life has been devalued in this jurisdiction. And I think we all bear the heavy weight of that. And that lack of value of the right to life, extends across all of our society. And obviously in the sector that I work, it impacts on disabled people, it impacts on women, it impacts on ethnic minority groups. And I always find that really staggering when you see it presented all together, in one place, and very emotional to hear all of that. In respect of democracy versus human rights, here, I don't really think we have a democracy. We have a government
that is responsible for a large proportion of our laws that we didn't elect and that we don't really have any voice or input into, and then can take forward legislation that is really poor, like the Legacy Act, like welfare reform, there's so many examples of detrimental legislation. We could just go on. And in this jurisdiction, we have been without an assembly in the last decade more than we have had an assembly. So in effect, we haven't really, we don't really have a functioning democracy. So all we have is human rights protections. The disabled people that we represent in the last political crisis said they felt like they were living under a dictatorship because of the lack of control they had over decisions in their lives. This is people who were starving and couldn't turn on life-saving machinery, and no one cared, and no one still really cares in terms of our functioning government. So in this context, I feel that is all we have. And the last comment, just reflecting on what Elaine has said in the area of disability, the kind of discounting cases. We have so many cases where there is CCTV footage of abuse happening, but because the person who has been abused and there is evidence cannot articulate impact in the context of how the PSNI or the PPS think they should, those cases are not making it to court. And there are examples in other jurisdictions of measures to facilitate statements of impact for people who are non-verbal or non-speaking, and we're so far behind here that we really need something to change to protect people's rights.
Okay. Thank you, Nuala. Do any of the speakers want to respond? Yeah. Okay.
Just very briefly, I mean, largely I agree with just everything that all your reflections, but just thinking about, do we really live in a democracy? Like last year, when we had effectively 2 years of no government operational installment. All decisions that were made by permanent secretaries, budgetary decisions that led to, I complained about, cuts to the sector. It's way beyond that. It's like life and limb stuff for people at the very margins, particularly people with disabilities, for women, for children. They were the ones most affected, also the ones with least access to power. And when you sit in front of the Secretary of State, a man you could not vote for, literally, I don't mean like on a moral level, I mean you literally couldn't vote for him. He doesn't live here. He will never face the electorate on this island, this part of this island. You may as well be speaking to a medieval king in terms of the power he has over you and the power you have in relation to him. So, when it comes down to it and you need something in your back pocket, human rights protections are usually the only things we have. So on the balance of things, that's kind of my feeling. Yeah.
Yeah, go ahead.
I get your point whenever you hear people talking about legacy, how little we valued life for over 30 odd years here. But I think also, if we don't actually deal with legacy and deal with it in a proper way, we're still the value in life. We pay lip service to it. We all have our own histories, we all have our own narratives, we all have our own lived experiences. But what we need to do is start to acknowledge other people's histories, narratives and lived experiences. And unless we hear them, we're never going to get to where people want to get to, this notion of reconciliation. I personally think it's at least a generation, if not 2 generations away. I think we can't even get to the stage of coexistence at the minute. In relation to government, I think it would be a huge step if we started to do a bit of joined up departmental government, where the health service, the education service, social services, the whole lot actually talk to each other and don't fight over what the budget is for each individual department. I had something else I was going to say there, but it's gone out of my head.
Thank you very much. Were any last minute questions or any further reflections before we... Sorry, Alan's just remembered.
I just remember what it was. Sorry. One of the things I think is, if we have to go to the European Court of Human Rights, we've lost already. Something has failed somewhere along the way. And that doesn't matter and that's the same for if you have to go to the court in Belfast. something has failed. The system has failed somewhere along the lines.
Okay. So, yes, Conor.
I was just going to make a suggestion, really, to Elaine, but possibly others, prompted by the question from yourself about which conventions are enforceable and which aren't. Because I think it's underappreciated that the Attorney General's Office has a power to issue guidance to criminal justice agencies under the 2004 Justice Act, but she's made very little use of it since the present attorney came into office. But what you can do there is marshal standards from all the conventions that are treaty-based into guidance specifically directed to, say, the PPS or the Prosecution Service in specific policy areas. So, for instance, you could do it in relation, there is one on domestic abuse and stalking, but in the other areas you were speaking about where you think a large part of the failure lies with those organisations, that might be one tool that could be pursued to the Attorney's Office and equally for others.
Okay. You don't need to respond. I'm
just thanks.
And on that note, thanks to our three very excellent speakers. Before I hand it over to Kevin to sum up today's event, we would like to show our appreciation to our three speakers in the traditional way. So I'll ask Kevin now to say a few reflections.
Thanks very much. And thanks to everybody throughout the day for all our speakers. I see from the agenda, I've been given half an hour to make my closing remarks. I can assure you that my positive obligation to you is that I'm going to keep it a lot more limited than that. I want to start by thanking our fantastic contributors today, without whom this event wouldn't have been happened or would have been possible. We've heard from a wonderful array of talented and knowledgeable experts and practitioners on the use of and importance of positive obligations, both at home and abroad and across Europe, and we're very grateful for their contributions. A special word of thanks to our keynote speaker, Dr. Stoyanova, who travelled all the way from Lund University and who literally wrote the book on positive obligations. So it's been really important to have you here, and you've provided us with a very helpful tour de force, an overview of the ECHR interpretation of positive obligations and also the role of the European Court of Human Rights in that regard. And that has been wonderful in terms of setting that broader context for our discussion today. We've also heard from a wonderful spectrum of local academics and practitioners from civil society who've explored that local utilisation of positive obligations in Northern Ireland and how that has evolved both positively and negatively in Northern Ireland. In particular, suppose we've heard from Alan and others how the positive obligations on the ECHR has really shaped traditionally, historically, our way of dealing with the legacy of the conflict, and how the interpretation of Article 2 and 3 compliant investigations literally were developed on the back of Northern Ireland jurisprudence and legal challenges in that regard. But we've also heard how the duties imposed and created under the Convention have become part of the fabric of how we interpret and understand human rights in a more broader sense here, both from those conflict-related cases, but right through a range of impacts and cases across social and economic issues as well, both housing, education, disability rights, social care, human trafficking, domestic violence and beyond from all of our speakers. There are clearly many success stories in the application of positive obligations here, but also, unfortunately, a number of ways and missed opportunities in how those obligations could have been extended and the scope made broader to the benefit of individuals in Northern Ireland. Those also go beyond the Human Rights Act and the Convention rights, because we could have made better use, as we heard from a number of speakers, of what should have been positive obligations under the Section 75 equality duties here, and that could have done much more to alleviate inequalities in our society. Unfortunately, we haven't seen that to the extent that we would have liked. For civil society, and I'm sure for all of us, the great beauty of positive obligations is both that proactive nature of the duties that are created and placed on public authorities, that they have to do something, that they have to act positively, that they have to take proactive measures to protect our rights. But it's also perhaps just as important for many of us in civil society that it's the empowerment nature that positive obligations provide to individuals who have been the victims of human rights violations that allows them to actively pursue redress and vindication for their own human rights. And that's for us, for me particularly, I think that's the power of positive obligations. So often in our work, it's that function of empowering individuals to actively make challenges to human rights violations in their own sphere and in their own name that has been important and the defining feature of this aspect of human rights. And we've heard from many people today positive examples of that, and we in our own work through our members have heard numerous examples over the years of how that has happened, and that soft power to challenge public authorities and decision makers, be it in special educational needs provision, be it in disability access to housing, or protection for people in care. There have been many positive examples of these obligations under the Convention and the Human Rights Act leading to successful outcomes for individuals. That's possibly why positive obligations have been a source of contention for the current UK government, because it can challenge them, because it can hold them to account. And they do offer a mechanism to say to the state, listen, you've got it wrong here. You need to go back to the drawing board and you should have taken action. But as Nuala rightly pointed out previously, even those soft opportunities and ways of interacting with civil servants and decision makers to hold them to account, those have been limited in recent years, and those avenues for having those soft impacts and self-advocacy impacts have been limited. It's also that response from the government is also why the media narrative around the human rights aspect haven't focused on the positive obligations. We've seen focus on other aspects, and the diminution of rights and the critique of human rights and the Human Rights Act in particularly has not focused on the power of positive obligations. We've seen it, lowest common denominator stuff and really scare tactics around the Human Rights Act in particular. And that's why Rory, Anne and I, when we came together to first discuss this event, it was in response to the direct attack that was being placed on positive obligations under the Human Rights Act and the Convention rights. If you cast your mind back a couple of years ago, and Rory mentioned this in his opening remarks, the Bill of Rights Bill, or the Rights Removal Bill as we termed it at the time, which was put forward by the UK government, really was an attempt to limit access to convention rights in a number of ways. And one aspect of that was to limit the role of positive obligations. And there were a range of proposals in how they would do that. They talked about limiting the scope for creating new positive obligations. They talked about limiting the interpretation of existing positive obligations. And the critique and the rationale for that was that it was too costly on public authorities, that it was creating legal uncertainty, and that some public policy issues were being decided by the courts. And the evidence basis for that was not grounded in fact. There was no evidence base for that, in fact. So this event is really a direct response to that challenge. It took us a while to get the event off the ground and actually into production, but we've got here in the end. And it's a response to that unsupported critique of positive obligations. And we've seen today that that simply isn't the case in terms of how positive obligations are framed in reality. Our collective experience as a civil society coalition of organisations, and from the evidence that we've heard today, is that positive obligations have been good for protecting and advancing rights, because it has helped create legal certainty for many individuals, as well as civil servants. Don't forget that they have in many regards have benefited from the clarity of the positive obligations and that proactive nature of obligations that they are bound to act, that has been useful for them in terms of clarifying the duties that they are under. The reality, though, is that this government, the current UK government, has spent 14 years really just trying to undermine the Human Rights Act and the Convention in all its formats. And the attack on positive obligations was part of a wider attempt to minimise the Convention rights. So from a campaigner's perspective, what has been, I suppose, most valuable today for me is that positive reinforcement of the role of positive obligations under the Convention, that it can be a force for good. Yes, maybe sometimes it's underutilised, maybe sometimes we could do more, but it really does fulfil a vital function in challenging public authorities to create better human rights compliant outcomes for individuals. And that we could do better in a Northern Ireland context for creating additional positive obligations or better utilising existing obligations that are there more effectively. My fear is that we've spent the last 14 years really preoccupied, particularly in terms of our resources at civil society, challenging the threat to the Human Rights Act and the Convention rights. And we haven't had the space and the time that we've needed to really educate and inform the individuals in our society that need the advantage and need the protection of those positive protections to utilise them in the defence of their own human rights. I think what we've done over the last 10 years in particularly is respond to the threats that this government have thrown at us. They've thrown the kitchen sink at trying to get rid of the Human Rights Act, individual aspects, individual rights under the Convention. And from a civil society perspective, significant resources have been utilised in responding to that threat. And I don't think we're alone in that regard. I think so many resources have been spent in that regard in terms of responding to that challenge. So I think we need to try and change the narrative around that. We need to use the opportunity potentially of possibly a change in government to shift the framing of human rights and to shift the response from the government to human rights. And don't get me wrong, there are organisations at a civil society level who day in, day out, at a grassroots advocacy level and in terms of casework, utilise positive obligations and advice around positive obligations to individuals. But I think so many of us have had to use, understandably, our resources to challenge the threat to the Human Rights Act, and it has taken us away from that where we would like to be, educating, resourcing, and creating better understanding of the Human Rights Act and the positive obligations that flow from it. So that's a balance that really needs to change. I think this event has been very useful for me, certainly, in terms of trying to set some of the thinking in train for how we might do that, and particularly in terms of clarifying some of the gaps that exist in terms of how those positive obligations apply here or don't apply here in comparison to other parts of the UK, but also across the Council of Europe jurisdiction as well. I see for the first time that we're now entering an election period, in an election period where none of the main party manifestos have committed or challenged or threatened the place of the Human Rights Act and the European Convention of Human Rights in UK law. That seems like a victory, but it seems like a victory at the end of a battle that should never have been fought. It's great, but it has distracted so much of our attention for so long, and we need to be doing more. We need to be advancing rights. We need to be adding to the suite of protections in Northern Ireland instead of protecting what we already had. We would love to be at the situation in the place where we're talking about advancing human rights through the mechanisms like a Bill of Rights, but unfortunately we haven't seen much progress in that in the last couple of years. We have seen some mention today of the inquiry by the Executive Office Committee, and hopefully that will be an opportunity to consider via domestic routes the expansion of human rights and equality protections in Northern Ireland. So I think this has been extremely useful in terms of exploring the scope of positive obligations, but also the limitations in terms of how it's being used, the potential to integrate positive obligations in a more expansive way into our interpretation of convention rights, but also how it can be added to new and emerging legislation at Stormont and beyond. So can I summarise or finalise by again thanking our wonderful speakers, our wonderful contributors, all of the amazing questions, to Rory and Anne for helping coordinate today's event, and I need to get the wording of this right, the Arts and Humanities Research Council in the Impact Accelerator Account in the University of Ulster for funding this event, without which it wouldn't have happened. And a final note, can I also please encourage you to fill out your evaluation forms before you leave, because that will be essential for us in terms of reporting on that funding. And finally, please join me in thanking our participants for their contributions. Thank you very much.